Hello, everyone, and welcome to the Capital Markets Adjudicators Policy Forum. I'm Tim Mosley. I'm the Chief Adjudicator of Ontario's Capital Markets Tribunal, and it's my pleasure to welcome you to this event and to thank you for participating. This is a highly serious event, of course, but every now and then some things take priority. So, yes, I have a Jays cap on, but I actually look really dumb in a ball cap, so that's not going to last very long. But anyway, in the meantime, we have in our live virtual audience not only appointed members, sorry, just one moment. Sorry, I'll continue on here. We have appointed members of the independent capital markets tribunals in Ontario, Quebec, and New Brunswick, but also appointed individuals from securities regulators elsewhere in Canada who carry out both adjudicative and regulatory functions. We are recording this event and we will make that available to any member of the public who wants to watch. All right, enough of the ball cap. Today's event is aimed primarily at people like me who adjudicate capital markets proceedings in Canada, but who do not have a role in policy development or other aspects of securities regulation. However, I know that today's program will be beneficial to everyone watching, and we look forward to an ambitious and I think interesting agenda. The goal of today's session is to help us better understand the context for issues that arise in our proceedings and to hear about emerging topics in securities regulation. We know that in our limited time today, we won't be able to deal with any of these issues exhaustively, but I'm confident this will be an excellent primer and an intellectually provocative foundation for further learning on our part. We have many distinguished speakers today, and on behalf of our entire audience, I express our deep appreciation for their contribution. I also acknowledge that the physical premises of the Capital Markets Tribunal in Ontario sit on the traditional territories of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Haudenosaunee, and the Wendat peoples. I acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. The Capital Markets Tribunal is grateful for Indigenous peoples' stewardship of the lands and waters we rely on. We will now take a quick look at our agenda for the rest of the day. We're going to move right to a panel in a moment about the business trigger and companion policy 31103. We'll talk about crypto assets and emerging issues in that field. We'll then take a half-hour break, talk about artificial intelligence, like we don't get enough about that these days, but we'll really have a good focused discussion from some experts. We'll have our usual annual discussion about takeover bids and shareholder rights. We'll have a short break. Then we'll have a half-hour session on digging into how markets operate today and things about trading and emerging issues there. And then that will be the wrap-up of today's program. Adjudicators, I strongly encourage you to ask questions. You should do that, please, by putting your question in the chat panel. So if you go along the bottom of your Zoom screen and click on chat, that should open up a chat panel. If you at any point just want to change the recipient in the chat window there from everyone or whatever it says to Tim Mosley, I'll keep an eye on the questions and I will curate them for our panels. Even if you do put a comment or question to everyone by accident, the recording that we will be making public will not include what went on in the chat. And when I pose a question to a panel, I won't identify who asked it. So if you're concerned at all, and I can understand that, you can rest assured that you will be anonymous in your questions and comments. So again, at any point in the session, if you have a question, put it in the chat and address it to me. I'll curate those and pose them to the panels. All right. We've had a couple of people having challenges. I think most of you are signed in. Perhaps just if anyone who's listening can just confirm that I haven't been speaking into the ether and nobody just send me a test message in chat directed just to me. I'm just going to wait a second in the hopes that that's happening. Anyone send a message to me in chat? Oh, says it's disabled. That's very strange. All right. That didn't work very well. We've got it on here. All right, we're going to continue on. You should have received a message, an email message earlier this morning. I apologize for the technical challenges here. We had tested this and seemed to be working. If you do want to send a question at any time, send it to my email address. If you don't have my email address handy, you would have just received an email address from my executive administrator, Ida Regalado, and you can send her an email and ask her for my email address. I will keep an eye on my email for any questions. And again, my apologies for the challenges we're having. With that, though, let's go straight to our first panel. We're going to talk about the business trigger in Companion Policy 31103. This is an interesting issue, I think, because for me, this is one of the issues where we really see the intersection and the tension between investor protection and capital formation. So with that, I will now welcome our first speakers. The materials for this event include bios of all of our speakers, so I'll give very brief introductions for two people who will talk to us about this topic. We're very fortunate to have with us Jeff Scher, who's a partner at Mintz LLP and chair there at the firm of the Alternative Assets Group for Canada. And we have Mike Denishin, who's manager of registration and registrant conduct at the Ontario Securities Commission. So we'll take down that slide, please, and I'll turn it over to Jeff to kick us off, please.
Wonderful. Hi, good morning, Tim, and hi, Mike, and thanks for having me on your show today. I'm just going to quickly check to make sure the share function works, and I'll pull up my slides so I can have them next to me as we go through this. If you can confirm, can you see this, Tim?
We can, thank you.
Okay, wonderful. So just by way of follow-up to the introduction, alternative assets is a very general way of describing what I do, which is represent, capital sponsors that include private equity firms, venture capital, hedge products, and real estate, generally speaking. Then there's things like digital assets. And I also represent a lot of founder-led, rapidly scaling businesses. And so I sit at that intersection between capital and people that are building and disrupting things. And that has allowed me to spend a lot of time thinking about the business trigger as I seek to have a lot of these clients obtain registration from all things such as, crowdfunding platforms to crypto trading platforms, to real estate developers who have to get a captive EMD in the door. And so this is a topic with which I engage quite frequently, and as such have firsthand experience with it. As a prefatory comment, I would say that in the last 15 or so years, since this policy framework has been adopted from the preceding trade trigger, generally speaking, it works. I think some market participants want more granularity. There's been requests for some more guidance, but I do believe this more of a principles-based interpretation is the right way to adopt a regulatory screen, such as the business trigger test or the BTT, while retaining that flexibility to make the right decisions to enable, continued capital formation, in particular for the SME segment, like the small, medium-sized business segment. It's been my experience in reviewing the enforcement cases that they really do seem to focus on those areas or those situations where it's been clear that the business trigger has been tripped over, or there's a broader scheme at play and sometimes criminal activity. In my practice, I can count on one hand the number of times that a client or a platform has received a letter from an enforcement branch of a member of the CSA. And in all instances, a concise response with whatever clarification they were seeking has been enough to dispatch the inquiry. And so I haven't had any direct experience as a practitioner that would suggest to me that there's been an overreach, perhaps, in the application of the business trigger test in my practice. Having said that, there has been some commentary in decisions over the years that would suggest that there may be an inclination to reach into the acts and furtherance of a trade, so that even preparatory activity could potentially be construed as triggering the application to BTT. Again, no direct experience, but there has been some musings in some of the comments that I've read. And I can also say that there's a very healthy level of activity in the market with market participants whose activities are likely would likely raise questions about whether or not they should, be registered. And so I put a slide together, with a couple of those examples to unpack on the call with you today. But I was wondering, perhaps maybe I can pause here and Mike, you could introduce yourself.
Sure. So I come at this obviously from the other side of the street, from the regulatory perspective. So I wear two hats. I'm the manager of registration. I'm also the manager of registrant conduct. So on the registration side, I know firsthand some of the challenges that firms have with obtaining and registration, getting the corporate structure in place, getting the individuals with the correct proficiency in place, enough working capital, and so on. But I also have a lot of experience in registering firms that act as intermediaries and act and at an arm's length basis raise capital for some of these issuers, and the issuers thereby comply with the dealer registration requirement, not by getting registered, but through retaining a registrant. And then on the other side, for registrant conduct, some of the things that we have to wrestle with from time to time are, is it fair and appropriate to those firms who are using a registrant or who have gotten registered themselves to be competing competing for investor dollars in the exempt market with a firm that isn't registered at all and is operating entirely outside that framework. And so what I'm going to add to this panel, I hope, is my perspective on some factors to consider when we engage in the balance between capital formation and investor protection, because that's inherently what the business trigger analysis comes down to. Go ahead, Jeff.
Sure. So in this slide, I just threw together some examples. I would imagine that everybody would have seen variations of this in the context of either the proceedings or with which you've been involved in, or in the context of the work that registration does at the various registration branches of the CSA. But this is an area where I would say almost weekly I would have either a client or I'd have exposure to a group that fits into one of these categories, and that's, again, in the real estate context. I mean, it's slowed down a little bit only because it's very hard to raise equity in the current market environment. But it is quite common for developers and other real estate market participants to consistently seek to raise capital. I think there's still some ongoing debate around at what point in reviewing the MIE guidance those capital raising activities would trigger the application of the BTT and or the need to seek registration. I consistently see compensatory schemes where the developer, an affiliate of the developer, is charging what they call a placement fee, or effectively a commission for raising the equity. And so we oftentimes will have conversations around how to either restructure or just actually tell them that is either not permissible or would actually trigger concerns that they need to be mindful of. The other category we often see, and seeing it a lot in the M&A market, is those advisors that are charging success fees on transactions, oftentimes taking shares in consideration for those. There's a lot of finder's fee activity. We still see lots of groups that with repetition and regularity are getting compensated for bringing capital introductions to companies that are seeking to raise it. And we're seeing a lot of private credit groups or lenders that are basically loosely affiliated groups that are charging compensation on basically syndicating loans or syndicating mortgages, and there's a fairly healthy degree of activity, again, not necessarily in the hundreds of millions, but there's real dollars being deployed through these types of arrangements. And another area that's increasingly hitting my inbox is groups that are syndicating effectively exposure to private companies that have some sort of brand recognition. So think of like your like Tesla or SpaceX, or and they're basically taking secondaries, creating a limited partnership, and then syndicating investment through the LP, sometimes charging or participating in the performance fee or the carry associated with any increase in price in that. So there's a very healthy list of things that hits my desk, more so where the client's being introduced to one of these enumerated categories, or they're borrowing money from the private lenders, et cetera. And so I very frequently have to have a discussion either with the client or sometimes learned counsel on the other side as to what our expectations would be in terms of how, these sorts of transactions can or should be packaged together, and or whether or not a licensed intermediary should be introduced, for the purposes of consummating the distribution.
Jeff, can I interrupt you just for a second? As you go on and as you're talking about these different scenarios, one thing that always strikes me, and it's a nerdy legal point, but here we are, right, is the way tribunals, especially those of us who aren't at the policy table, are applying the business trigger test is different in the case of a companion policy than it is in the case of a national instrument. So the national instrument forms part of, in Ontario securities law. The companion policy doesn't automatically. Our tribunal in a number of decisions has acknowledged that, but said we adopt it because it makes sense and we're going to apply it. So I guess what that means to a capital market participant or counsel to a participant is if you think something ought to be tweaked about that, and you're worried about a case that might come before the tribunal, you've almost got a two-step process. Maybe one is to try to influence the regulator to amend the companion policy, but even if you're successful in that, you're still not necessarily done because the tribunal hasn't yet adopted that change. And I take it from your comments that maybe that's just all kind of academic and practically speaking the system works, but I'm just curious as to whether that ever has crossed your mind or whether, as far as you know, that causes any kind of problem. If it doesn't, great, we can carry on.
No, I would look, I as a practitioner, I would take the view that if someone was going to use that as a shield, for example, it's because it's the only thing they have available, and that to me is not something I would necessarily. I think this is a substance over form analysis, and I think that the guidance in the companion policy, why it is not technically codified, provides a great indication as to the factors that will be applied, and has allowed practitioners such as myself, 15 years of advice, to be delivered. And so I do see, I've seen that, acknowledged in some of the decisions made by the tribunal over the years. But again, as a practitioner, that would be, I would consider that somewhat flimsy, so to speak, if that were to be something that someone were to raise for a reason not to be able to proceed on that basis. In fact, I would argue that we need some more guidance, around things like finder's fees, around things like what it means to disguise compensation, because, and again, I'm not, I'm lucky and fortunate so far as my clients have not necessarily, ever found themselves in front of an administrative tribunal, or at least as a practitioner, I try to screen out, platforms or individuals that may be exhibiting, those tendencies. But sometimes the additional guidance will help, because oftentimes as counsel, what will happen is, I have an issue or desperately needing to raise capital. I've got a private lender dangling a check, and I'm saying, well, wait a second, that doesn't make sense. And I'm, somebody here is going to get hung up, and let's just make sure we understand. And having this guidance, Tim, is often very helpful, because it allows us to say, well, wait a second, we have something we can point to, that we can derive, some measure of comfort from, provided it's applied consistently. And I'd say, again, through most of the decisions over the years that have been rendered, I would say it has been applied fairly consistently.
Great, thank you.
So I don't know if you had any other questions or comments, but I think, again, my takeaway here, or as I was thinking about where we currently sit, is that I'm generally confident that this is a framework that can continue to be applied, does not necessarily need any significant overhaul, but some additional guidance wouldn't hurt, in particular around things like the MIEs, like what it is, to basically be an extension of an operating entity. There have been musings in some of the decisions around, what the right balance or threshold should be about, what it means to have an operating business versus what it means to be consistently seeking to raise capital. And then that in and of itself could trigger the application of the business trigger test. But I think I'll pause it here and perhaps let Mike take over.
Okay, thanks very much, Jeff. Tim, if you wouldn't mind, I wouldn't mind kind of starting with the question that you asked Jeff, which is about the companion policy. So first of all, I should say, because I've been advised to say it and I believe it, that these are my views and they don't necessarily represent the views of the OSC generally. But kind of a twist to that disclaimer in the context of the companion policies is that I'm of the view that while a companion policy doesn't bind an adjudicative panel, it does bind staff's interpretation of the national instrument, right? Like Baker versus Canada's a Supreme Court case, it's an immigration context, but it's a situation where they found it unreasonable for an agency to take a more aggressive approach to its legislation than what it's said it would do in the context of its published guidance, right? So what I always tell my team is that the companion policy binds us even though it isn't law and even though it doesn't fetter the discretion of an adjudicative tribunal, right? Like if we publish it, then we have to adhere to it in terms of if we say this is where we draw the line, then that's where we ought to, in practice, draw the line. So I mentioned earlier that the business trigger is generally a balance between the benefits of registration and the burdens of registration. And another way to look at that is kind of investor protection, confidence in capital markets on the one side, and capital formation, inviting and thriving markets on the other. And I have two arguments that I want to bring to this panel today. And so the first is that when we consider the benefits of registration, we should consider not only the gatekeeping function of registration, but also the substantive investor protections that are conferred by the dealer registration requirement. And then the second argument I want to make is I think we should consider not only the perspective of those engaging in the capital raising, Jeff's clients, but that we should also consider the reasonable expectation of investors when their interest in investing is being solicited by these parties. So, like I said earlier, an issuer's activities don't necessarily mean that the issuer itself has to seek registration. They're always free to use a registered dealer. Now, this attaches a cost to raising capital, but it does not require an issuer to kind of devote the financial and human resources to establishing an effective compliance system in a fully registered dealer. So the dealer registration requirement is not only gatekeeping, background checks for integrity and proficiency and solvency, and forms and fees and that kind of thing. There are also investor protections that attach and only attach when the dealer registration requirement applies because of the ongoing registrant obligations. So if and only if a registered dealer is involved, then, for example, the dealer is required to deal fairly, honestly, and in good faith with clients under Rule 31505. And if, but only if, a registered dealer is involved, the dealer is held to, know your client obligations, know your product obligations, and then considering KYC and KYP together in a Venn diagram to determine whether the investment's suitable and in the best interest of the client. If, but only if, a registered dealer is involved, conflicts of interest are required to be addressed in the best interest of clients after client-focused reforms. A client is granted access to a complaint handling process and a dispute resolution service such as OBSI. And then finally, KYC is not only understanding someone's investment needs and objectives, but also it verifies their identity. And so as we consider kind of where we fit in the ecosystem of AML, anti-terrorist financing, the various reporting and property freezing duties do apply to entities in the business of dealing, but do not apply to most securities issuers themselves. So that's an additional layer of systemic protection that occurs if we determine that the registration requirement applies. So I'm going to use an example. I know Jeff referred to GoTo. I'm going to talk about a decision from 2023 called Stinson. And I'm not here to kind of relitigate the finding on the business trigger, but just to talk about sorry, I lost my video for a second. I don't mean to relitigate the business trigger, but I just want to talk about the implications of there not being a business trigger in that case. So in that case, the tribunal found that the parties were not in the business. They did not accept the respondent's agreed statement that they were in the business of trading in securities without registration. But the tribunal found that the respondents acted contrary to the public interest by failing to segregate investor funds, failing to maintain accurate records of funds received by investors, failing to properly record the use of investors' funds. Now, if dealer registration was required, then those breaches are already included in a finding of a violation of the dealer registration requirement. But in this case, the tribunal had to go to a broader, and I would argue a more nebulous standard of conduct contrary to the public interest. And you didn't need to get there if the panel determined that dealer registration applied. Again, not to challenge the finding, but just to point out the implications of that. So my first argument is that we should consider the gain or loss of these investor protections as well as the gatekeeping function when we analyze this balance between regulatory burden and capital formation.
So I'll put you on the spot, Mike. Do you think that those criteria are adequately set out in the companion policy, both in terms of the substance that's there and the level of detail, the extent to which they are principles, as Jeff described, versus prescriptive rules?
Well, I think Jeff's real world experience suggests, Jeff, I took some comfort in him saying that he finds it useful, but I also take his point that more guidance would be more useful, right? The thing about the balancing test is it's not one of those, all of these 5 things have to be met. Some of them are in tension with each other, right? Because some of them it'll say like you aggressively reach out and solicit on your own, but then you act as an intermediary or market maker. Like you can't satisfy all the tests of the business trigger. The question is whether you satisfy enough of them that we've determined that a registration issue arises. So I think to your point, if I'm being candid about it, I do think that we'd benefit from more guidance.
And just practically speaking, is the process, so when Jeff or someone like him wants to advocate for more guidance for MIEs or whatever the situation is the process essentially the same as it is if someone wanted to advocate for a change to a national instrument? Is the distinction between a formal national instrument and companion policy go away at that point?
Well,
so there's a rulemaking process for the national instrument.
That's what I'm tripping up on, right? Because because it's a national instrument, it's also a national companion policy. So this is a discussion that we would have to engage in with our CSA colleagues, and we require buy-in and sign-off and so on. So we recognize that it can be challenging, but on the other hand, we do have good touch points within the CSA on policy. We meet weekly, bi-weekly, quarterly, depending on the particular working group that's convened. So, I would just encourage Jeff either to use industry associations, or he can himself, reach out to us and put it on the table for us to consider. So I'll get to my second point, and then we can open up some time for questions, which is the drafting of the business trigger itself. And I'm going to share my screen just to illustrate the point. So, the tribunal decisions that I've reviewed consider the daily duties of the individuals at these issuers. Do they have a role beyond capital raising? How much time is their day-to-day duties? How's their time divided? Are they compensated for capital raising, and so on? But if you look at what I've highlighted in the Act, there's also the issue of whether the individual is held out to the prospective investor that they're in the business of trading in securities. And so in advance of this, Tim suggested that we take a look at a few cases. And these are all cases in which the tribunal found that the business trigger had been tripped. And I think the through line here is that each of these issuers held out to the prospective investor that they were in the business of trading, even though they were also issuers. So just quickly, the Mayer-Sean case, you see trade shows, email blasts, investment group meetings. He used slogans such as, it's a huge market opportunity, you can double your money in 1 year or less, returns up to 50% in a year. To me, this is no longer answering questions about a business plan of an issuer, but holding out an investment opportunity. And I think that's relevant to the business trigger based on how the black letter of the Act is drafted. Same thing in Paramount, you see promotional materials, there was an offering memorandum, documents and websites paid referral agents. And in Moneygate, they produced and disseminated literature, videos, social media posts, investment seminars, and they provided training sessions, in fact, about how to borrow against your home equity in order to take advantage of these investment opportunities. So in my view, I'm just stopping sharing. Okay, so in my view, when these issuers hold themselves out through these strategies, this is consistent with what an investor would expect from a market intermediary. And so I think we should consider the investor experience as well as the substantive protections of the registration regime when we engage in this balancing test. Because to me, the investor doesn't have access to the outlook calendar of the issuer and how much time they spend on capital raising versus making widgets at their factory. What the investor does see is a sales pitch, a holding out as engaging in the business of trading. And I think that even for issuers, they have to be mindful of this part of the test in Section 25 in determining whether or not they trip the business trigger.
Thanks, Mike. Can I just voice an argument we hear sometimes in cases? I'm not saying this is my view, but I'll voice it, and perhaps Jeff, you can say what you think about it, and Mike can respond. But particularly for some sectors, and particularly capital-intensive sectors, if it's a startup, but if it's a tech startup, and they're going to need a lot of capital to get going before they can really start carrying on business in the casual sense of that, they argue and have argued that, well, we need to get out there and raise capital. And yes, maybe in the early going, it looks like all we're doing is hawking shares, but that's what other choice do we have? And if we're going to be out hawking shares, what's wrong with us saying good promotional things and all the rest of it? I mean, that's a pitch we hear, and it's got some appeal to it, but I'll stay neutral on it. And Jeff, invite your comments.
Well, just very quickly, that mindful of the time that we have left, where my mind goes is a couple of things. Yes, I actually have a number of issuers that have been raising capital for about 2 years. One of them has an RFP with the Canadian military. It's going to take 24 to 36 months before that contract hits. In the meantime, they're building. Now, what did they need to do? Raise. So 6 or 7 capital raises. Where does that sit, relative to the guidance? So I can think of a number of examples where you could argue that they're bumping up against it because, there was some, I forget which case, it was 15,000 in revenue, maybe that was Marchand, versus what they were raising. Sure. But I find there's usually other factors at play that would allow the tribunal to come to that conclusion. And none of these are really taken in isolation. They're all weighed relative to one another, as you were saying, Mike. The other thing is, look, the representations that are being made, I actually don't think are types of representations that a market intermediary, i.e. a dealer, would make. I mean, I don't know any IROC client of mine that says 50% guaranteed, when they're pitching junior resource, equities from their equity capital markets desk. Just doesn't happen. But I take your point. And then third, we have the statutory remedies for misrepresentations under, an offering memorandum. So the simple fact that you're generating a document designed to solicit investment, has its own remedy, so to speak. Again, not to detract from, what the business trigger does for us or what a registrant in the mix does in terms of, putting in the right behavior and the right outcomes for investors. But there are other remedies at play as well.
And by the way, we started 5 minutes late. We've got about 7 more minutes here, so I don't want to have to rush through points. Mike, do you want to respond to comments Jeff just made?
Yeah, well, I mean, so first of all, I agree with Jeff that these aren't things that you see from registered firms, because registered firms are subject to obligations around dealing fairly and honestly, and requirements to maintain an effective compliance system, which includes their marketing outreach. But I think Jeff and I would probably agree, though, that there's a difference between describing your need for capital to your network of, your professional network, your institutional investors, and so on, and going out to retail clients and saying, there's a 10% return that's here if you act now with this opportunity. And I really think it matters. I think it matters as much or more than the fact that this entity is also an issuer in terms of how it's presented and whether there is this holding out aspect of engaging in the business of trading in securities. I don't know if Jeff has a reaction to that.
I think it follows my similar comment, which is, holding yourself out as being in the business of trading, to me, equivocates someone who's licensed to be in the business of trading. And the behavior doesn't overlap because, like you said, those who are licensed would not act imprudently. I think this is a matter of, these are collective investment schemes, overly promotional materials, misrepresentations effectively. And so I look to this more as, the substance of the disclosure that's being made around, the security versus the fact that, it's a sale of the security in and of itself, if that makes sense.
But Jeff, if you had I'm just saying, if you had an issuer client, would you advise them to have or not have an investment seminar where they have charts
Oh,
showing
absolutely not.
forecasted.
No, absolutely not. No. They either wouldn't be a client or they wouldn't do it. It's one of those binary.
Yeah.
But I wouldn't be pointing to the to this particular aspect to dislodge them from that view, right? It would be every single person who buys under that offering is going to have a 180-day put right to come right back to you when everything you've said doesn't pan out, right? Or there's a misrepresentation around the use of proceeds, or you've conflated personal versus corporate in the bank account. Those are the sorts of things where that's where we tend to focus the discussion. And the statutory put right, as I call it, for the misrepresentation seems to carry, it's a lead feather in the discussion much more than what we've been talking about today. That would be the way that I would dislodge them, Mike, from the discussion.
Let me just jump in and say we have a few more minutes. We fixed the chat problem. So if anyone has a question, you can go into the chat window and specify me as the recipient. And if you have a question, pop it in there. So in the meantime, but just let me come back to Mike and Jeff. We could still have a couple minutes. Any other points you want to add or elaborate on that we've talked about?
No, not particularly. My comments also not representative of the OSC for whatever that's worth. And the work that we've done together. But
no. On that point, I agree with Jeff entirely.
Well, that's great. I really appreciate both your contribution. I will say, if it hasn't been obvious from my comments and questions, that in my experience, some of the hard cases on this topic have been ones either where there wasn't lots of hype, or if there was hype, it was kind of within reason, and you can almost really separate it from the more technical question, if you will, of was this entity behaving like a dealer? One of the, I'm paraphrasing, but one of the 5 or so elements from the business trigger test, and those are the tricky ones, and I'm interested in kind of what lies behind that and drawing the line. And I think as industries and sectors evolve, it will continue to be interesting. We do have a question. Do you think that a separate remuneration, if there's separate remuneration, I take it for capital raising, is a key criterion? It's one of the factors that's been mentioned. How important?
Yeah, I do think it's a key criteria. I think it's a key criteria for 2 reasons. I think first of all, it's a key criteria because that is behavior similar to a registrant. And so there's the factor of compensation, like doing this for a business purpose, but then there's also behaving like a registrant, because registrants also attach a cost to raising capital that way. But also, again, if you consider, I think because you're receiving compensation for raising capital, like, shouldn't that be an interaction given the inherent conflict that provides? And there's always a conflict, like you're paid to sell something, so you're going to sell something, right? But given that you're starting from a conflicted relationship, shouldn't there be registrant obligations, like making sure that this investment's suitable for someone that you're getting paid to sell the investment to? Shouldn't the investor have? Yeah.
Some respondents would say and have said, okay, we have a person who works for us and they're not on commission, but they're paid salary and they spend about 10 to 20% of their time, facilitating the sale of capital. Anyway, there are hard cases on this, and I think it's a good question. Jeff, did you want to add anything?
I agree. No, I agree. I mean, compensation, I describe it as a lead feather on the scale when you're measuring these factors, and it's the easiest one to use because it's quantitative. Now, $2,000 versus $200,000. Yeah, maybe we make the argument as it was made in one of the cases. But that's the one that we can all nod. Now, of course, to your point about the employee or the IR person, on staff, where I typically see it is the finder, the intermediary says, okay, well, what's 5% of 100 grand? Okay, that's $5,000. Sign me up for a consulting fee at a fixed amount. That's typically what happens in those type. So those get harder to pierce. Because you don't have, it's a consulting agreement, it's fiscal advisory, whatever that means. So, that's where we tend to see a lot of that activity. That's where it tends to hide. But if you can unpack it and click through it, then yeah, that is to me the most ascertainable measure and the one that we tend to focus on.
Yeah, it's a good question.
Great, thank you. We'll wrap it up there. Mike and Jeff, thank you so much for your time, your contribution. We really appreciate it. It's a good, robust discussion of the topic. So thank you.
Great. Thank you.
Very much. Okay, bye.
Great.
Bye.
All right, we're going to move straight on to our second panel. I'm going to introduce Usman Sheikh, who's going to moderate this next panel. He's our returning champion. He's done this for us the last couple of years. Usman's the chair of the Blockchain, AI, and FinTech practice for Canada at Baker and McKenzie, LLP. And I'm going to let Usman introduce his panel members. Take it away, Usman. Thank you.
Yeah, thanks a lot, Tim. Really appreciate it. Good to see Mike and Jeff as well, who knew sparks would fly on a business trigger panel, but should have joined a little bit earlier for that. I really wanted to thank all of you for having us here. We really have a star-studded panel with an extremely impressive group of speakers, and maybe they could turn on their cameras as well. We have Laura Fouin, she's Associate General Counsel of Coinbase. We also have Kareem Hamasni, who is the head of RBCX's decentralized strategy. We have Emmy Hauser as well. Do we see Emmy here? Who is the Senior Director of Legal and Regulatory Affairs at Figment as well. I'm just going to double check. I'm hopeful that Emmy is here. Oh, there she is. Okay, perfect. So we have actually a lot of ground to cover over the next 50 minutes. And in truth, this panel could cover a whole host of topics under the heading of crypto. And so we've decided to really limit the scope of this discussion to 4 topics, ambitious at that. So the first will be on tokens. The second will be on stablecoins. We're going to try to cover staking as well, and then also DeFi too. So Kareem, let me maybe start off with you. And I know that you have a deck to help us out with this and sort of put the weight of this question on your shoulders. But what are each of these and how do they interact with one another? And can you somehow miraculously explain all of this in a few minutes?
Thanks, Usman. And I'll do my best. So I'll quickly share screen. So I'm going to do my best to try to define what the tokens, stablecoin, staking, and DeFi are at a very high level, just to have a general understanding of what these technologies are. So first, what are tokens? Well, if you think about tokens in the traditional sense, you might think of things that you pass around, kind of like coins or cash. But in the blockchain sense, the blockchain operates very similar to a bank in that it's a ledger that keeps track of accounts and balances. But the difference between a bank ledger and a blockchain ledger is that the blockchain ledger is multiplied and distributed across a vast global network of computers that make up the blockchain network. And if you look at the ledger for Bitcoin, for example, you will see that it has wallet addresses that have balances. And if you look at the Ethereum ledger, it too has wallet addresses that have balances. But the difference between ledgers like Ethereum's and Bitcoin is that the Ethereum ledger and the Solana ledger and other different kinds of ledgers can store more than just native Ether, which is the native currency on Ethereum. They can store all types of different tokens on that blockchain that are defined in that blockchain. So things like stable coins, meme tokens, ICO tokens, utility tokens, and so much more. And smart contract developers, they can create their own tokens on these blockchains to interact with the smart contracts that they make. So they can code their contracts to work with these newly created tokens. So for example, if you have a contract that performs some kind of function, you can use the token to activate that function, much like people use tokens to activate an arcade game. And these tokens typically come in 2 varieties. There are fungible tokens and non-fungible tokens. Now, fungible means that each unit is indistinguishable from one another in utility, whereas non-fungible means that each unit is unique from one another, almost like a certificate of authenticity. Next up are what are stablecoins. And so stablecoins are more than a crypto product. They represent a shift in how money can move globally. Stablecoins are digital tokens pegged one-to-one to fiat currency equivalents, but also to commodities like gold. And they are fully collateralized via liquid high-quality assets and redeemable to users. And when it comes to what they can do, they can see some material improvements across a number of different parameters. You can have faster speeds in transactions using some of the more high-performant blockchains. So these tokens essentially just transact on the blockchains in substitute of that of a crypto asset. In many instances, you can reduce costs of transactions on some of the fastest blockchains. You can get transactions with fees that are less than a penny. And what's really interesting about it is that you can program smart features to these payments. These payments are programmable. So you can include things like payment limits, escrow services, and so much more, all governed by smart contracts on the blockchain. And we're seeing a lot of major global FIs and fintechs and startups really start to lean into the space. Major banks like SocGen over in France have released a tokenized euro stablecoin. Fintechs like Robinhood have joined consortiums like USDG, which are stablecoin consortiums. And firms like Sling Money are startups that allow for cross-border payments in over 100 different countries using stablecoin rails. Next up is what is staking. Now, the definition of staking is the locking of crypto to help secure a blockchain network and earn rewards. So how it works is that proof of stake blockchains like Ethereum or Solana rely on networks of validator nodes instead of miners, and the owner of the validator will lock tokens with the network to participate. So in other words, they'll put skin in the game in order to participate as a validator, or they can delegate tokens to a different validator. Now, what validators do is they'll verify transactions and maintain the ledger. They do their part in running this in a decentralized way. And for those validators that perform honest behavior, they get rewarded with rewards, whereas bad behavior gets punished with something called slashing, where they'll actually lose some of their initial stake. And last up is what is DeFi? Now, blockchain is meant to remove the intermediary middlemen in systems and industries. And so if you think about it, financial services firms are intermediaries today. What decentralized finance or DeFi aims to do is to replace traditional financial infrastructure with impartial and autonomous smart contracts that live on blockchains like Ethereum. So many of the systems that power the capital markets today can theoretically be done in a permissionless, decentralized open source platform without any intermediaries that seek rent or rent-seeking middlemen. So if you think about today, we trade stocks through exchanges like NYSE or the TSX, which what they do is they pair a buyer with seller of shares. On blockchains, decentralized exchanges like Uniswap, PancakeSwap, and Curve help buyers and sellers of tokens to trade. It pairs a seller with a buyer. Today, we need financial institutions to issue a loan against collateral, but on the blockchain, decentralized lending protocols like Aave, JustLend, and Compound can allow you to borrow against your tokens and using your tokens as collateral. Today, we need quant funds offered by asset managers to invest in and grow your money. On blockchains, yield aggregators like EtherFi, Liquid, Yearn Finance, and Sommelier seek and capitalize on inefficiencies in crypto markets for financial gain to grow investments. Now, in general, it's expensive to run a traditional financial infrastructure. IT teams at banks are quite big. Maintaining systems and uptime is a challenge. Today, relatively small teams of developers can write a smart contract application, deploy it to a blockchain, and supplant traditional financial functions, all done without an intermediary, in theory. There are oftentimes smart contracts that are decentralized in name only, but nonetheless, the theory is that you can offload that into a smart contract form. And that's it. I'll just go ahead and stop sharing. And I hope that was enough detail this month. Thank you.
Yeah, no, it was super helpful to really set the scene for this discussion. So let's bracket, if I may, staking and DeFi, and we'll come back to that in a moment. And let's maybe focus on tokens. So Laura, here we are, 2025, almost 17 years to the date that Satoshi Nakamoto, this mysterious individual or group of individuals, released the white paper on Bitcoin. And we're still debating about the legal characterization of all these various tokens that Kareem was just mentioning. Why is that? And why is this issue so important? And maybe if you can also explain to the adjudicators some of the divergence that we've been seeing in at least the United States and Canada and some recent developments on that.
Sure. Thank you, Usman, and thank you everyone for inviting me to present. And I'm glad to be here and getting the opportunity to clarify why it's unfortunately still controversial to have a clear characterization of what tokens are. In the US, we've seen developments lately with the Clarity Act to see really three types of tokens being characterized as either really something that is an investment, something that is a utility token, or something that is a payment token. We don't have any projects currently in Canada that would clarify the world of tokens and characterize them in these three different buckets or any types of buckets. it will not be a surprise to anyone here that defining something as a security or not has very important impact on the way you issue it, the way you can or cannot trade it, the way it's custodied. So determining that a token is a security implies, of course, registration as a dealer, prospectus in order to issue it, liability that comes with it, and all of the custody that comes with requirements that comes with a security. So that is ultimately the question when you decide whether a token is or isn't a security. In Canada, we've taken an interesting position where we haven't followed exactly the US, where what they have really focused on the token itself, characterizing it as an investment contract or not under their Howey test, which is the equivalent of our Pacific Coast context of investment contract. We have also taken the position, well, the Canadian securities regulators have taken the position to look at the economic reality of the way tokens can be traded on what we call a custodial platform, and characterize that relationship itself as an investment contract. So historically in Canada, the Canadian securities regulator really took a platform-centric crypto contract position, where they would come in and say that, well, if the user, once it has traded, bought a crypto token, whichever token it is, whether it is clearly a commodity, clearly the equivalent of an investment contract in and of itself, the equivalent of a derivative in and of itself, or really not, such as Bitcoin being recognized as a commodity, for example, the fact that holding the token is performed on the platform, that the user remains dependent on the platform's capacity to deliver that token to the user, whether it's solvency, it's literacy in delivering it, that relationship between the user and the platform is an investment contract. Most of our regime in Canada is really based on that platform-centric approach. What is the relationship between the user and the platform? In the US, as I said earlier, they've taken more of a token-centric approach, which is whether or not the token in and of itself is an investment contract or a security, because it falls under another prong of this definition of a security. And in that perspective of really the token itself, we have a very interesting case earlier this year in Quebec by the Quebec Financial Market Administrative Tribunal, who followed in the steps of a US case that took a very narrow interpretation of what an investment contract is in the context of crypto. And it was considering the activities of a crypto finfluencer and wondering whether or not its activities constituted advising in securities on the one hand, and could have constituted market manipulation on the other hand. On the advising in security piece, the tribunal decided that because the respondent took control of the investor's token, traded it himself on a decentralized exchange, and kept a share of the trading profits without the investors having any right to participate in the investment choices, the tribunal decided that that was investment management. However, very interestingly, on the market manipulation claims, the tribunal rejected the characterization of the token as a securities. And that was based on the fact that there is a clear distinction, according to the tribunal, between a situation where individuals make a contribution to the promoters of an asset itself for the purpose of financing the development of an underlying venture. That falls under the investment contract analysis. However, on a secondary market, once individuals simply purchase assets from other individuals, already own it, and were not promoters, through decentralized platforms in what the court has really described as programmatic sales carried out using algorithms in these decentralized exchanges, that is not an investment contract. So it's an important development by your colleagues in Quebec that really gets a little bit closer to what the US has done and the analysis that they've had lately.
Yeah, thanks for taking us through the whole history of it. But yes, you're quite right. I mean, it's interesting because in the United States, they haven't really used or relied upon this crypto rights contract theory. And in fact, in previous years, when I've hosted this forum, we had the Deputy General Counsel, and Tim, you'll recall this, from Ripple, who is sort of duking it out in the courts in the United States on this issue of whether the secondary sale will be captured as a security, and they ended up being partially victorious in the U.S. courts. But they indicated that even the SEC wasn't sort of raising this theory of a crypto rights contract theory in their own proceeding in the United States. So it was very foreign to hear that interpretation of this investment contract test in this context. So I think the chief adjudicator has put in the chat a link to that case that you were mentioning, Laure, which is the Gagnon case. And it's a really interesting read on those points. I don't know, Emmy or Kareem, if you had any comments on this before we moved on. No. Okay. So maybe Laura, just on the same topic, if you don't mind me asking then. So let's say if that case was correct and, you know, that theory were to sort of fail. And the idea is that if you have a crypto platform and if it's a custodial platform and Laura has her phone because she has an account with that platform and she has no actual possession of her crypto, and all there is a line pointing to 5 Bitcoin that she owns within a pool of assets that's being custodied by the crypto trading platform. Like, that's the crypto rights contract itself, and that's how a platform then falls within the jurisdiction of a securities regulator, because there's a trading or distribution of these crypto rights contracts, as opposed to the crypto asset itself that may be not a security in and of itself. So let's say if you weren't to have that theory, then what? So who sort of regulates what sort of stands in the way? And I guess what they're doing in the United States is looking at maybe bespoke legislation. You mentioned the Clarity Act, but what would you see as that, you know, sort of next step if that theory were to not hold up?
Oh, you mean the entire investment contract theory to regulate custodial platforms, or how can we regulate the DEX ones? So the ones that under this decision has been said as not being trading in securities, because I think that's really where the line in the sand has been drawn here, and it is the secondary tradings on decentralized exchanges are not trading in securities. So then what is the risk and what needs to be regulated on these decentralized platform? And I think there is a big difference between custodial and non-custodial, of course, as you said, between having your pooled assets under a Coinbase FBO account and having them in your own wallet immediately delivered. And the what changes is the risk. It's when you're on a custodial platform, in my view, the risk is, as the securities regulators have said, your counterparty risk to the platform, custodian failure, hacking of the central pot, fraud, insolvency, asset freezings. When you're in a non-custodial platform, the risk is the operational risk, is really the user itself losing its key, losing its seed phrases, any error in the transaction, and of course, bugs in the smart contracts or anything of the sort that's really more operational. What we see in the regulation is in custodial, and same thing with the market structure plans in the US, is really more the full regulation of the platform itself and its interaction with the user. Whereas in the non-custodial world, we don't have anything yet, but what we have is the IOSCO's papers, for example, on this, who clearly state same activity, same risk, same regulatory outcome. So what they're trying to look at is how can you find the place where there is a similar activity and the same regulatory outcome to get. I'm not sure I answered the question, but I
Yeah, and we'll come back to that in the DeFi
yeah.
context. Like maybe push a little bit to staking. As Kareem had
Okay.
mentioned, some blockchains really require parties to stake those crypto assets in order to, really help validate transactions on given blockchains. So Emmy, your company is right in this area. Kareem sort of outlined it in his presentation, but why is staking so important to some blockchains, and how is that activity really regulated in Canada? And if you don't mind touching a little bit on the US, because there's actually been some really recent pronouncements by the SEC under the new Trump administration on that point as well.
Yeah, for sure. So I'm Emmy Hauser. I head up the contracting and regulatory side at Figment. We're an institutional validator. So staking is literally what we do right now, and we partner with Coinbase as well. So Laura's very familiar with us as well. So staking is really important to all the big networks outside of Bitcoin, right? Like Ethereum is the #2 market cap cryptocurrency, pardon me. And it relies on staking as a mechanism to propose the blocks and to validate the blocks to allow the blockchain to continue to run, if you will. So what happens is we run nodes, which is basically just infrastructure, and our clients or other retail participants stake tokens as collateral. So what that means is you're locking up your tokens to our validator node. You're saying, I'm not going to transact with these tokens right now because I want to secure the network. I want to lend my computing power in that way so that the network, like through locking up my tokens, the validator can use that power, that voting power, that collateral to propose new blocks. So it's the same on Ethereum, as well as Solana is another big one you may have heard of. So when you stake your tokens as collateral, that validates validates transactions to allow them to be included into a block. And the more people that stake, the more secure the network is, the more people are participating in consensus, right? The more people that are saying, hey, I saw this transaction too, this transaction is right. And that helps us reduce the risk of attacks or fraudulent transactions. So in exchange for locking up your tokens, right? So you're not able to transact with those tokens. You can't access them, subject to various like timeframes around they would call it unbonding your tokens. And so in exchange for locking up your tokens, you receive from the network newly issued tokens, depending on the network, of course, everyone's a little bit different. And also you get a share of transaction fees, right? If you want to do a transaction on Ethereum, for example, you have to pay gas. And so as a staker, you will get a portion of those transaction fees. So in the end, you lose the ability to use your tokens for a time when they're locked up, but you do get rewarded for doing so. And so in Canada, it's sort of interesting, as Laura was saying, like we've done it a little bit differently. For retail investors, the focus is really not on staking as an activity itself, but on the crypto trading platform itself that is offering staking, right? So I'm sure everyone knows, but to operate a crypto asset trading platform in Canada, you have to be registered with the CSA as a restricted dealer, and then you are required to pursue registration with CIRO following that. And again, instead of regulating us, the node provider, the CSA will put particular requirements on each CTP, and these may vary based on the restricted dealer opinion. But for example, the CTPs require stakers to give their explicit consent to stake. We can't just your assets can't be staked without you knowing. There has to be disclosure of the risks of staking, and that has to be clear at every time that you are staking. And if CTP like Coinbase were to use a validator provider like us at Figment, they are required to do a bunch of diligence on us in order to meet the CSA's requirements. So they have to assess the risk of the protocol, the mechanics, and then obviously us as a validator, right? Do we have our SOC 2, SOC 1? How do we do our own key management and security? So a lot of what we do is just making sure that our security systems are robust and so that we can meet the CTP's requirements vis-a-vis the CSA. Again, there's asset segregation, making sure that Figment isn't commingling anything, and that's never something that we would do. And like we've worked with custodial providers in Canada to speak with the OSC to get them comfortable that our services would meet their requirements. So that's really how it is laid out in Canada for retail investors. So I guess in summary, they just care about who's offering the staking, not necessarily the staking provider itself, except that we have to, be able to show that we meet certain due diligence requirements and security requirements. For institutions, again, a lot of it's just about fiduciary duty and the prudent investor rule, right? They'll look to, I think it's they'll just do due diligence on us, right? If they want to use a third-party staking provider. And I think a lot of those ideas are laid out in CSA Staff Notice 81-336. And again, it's sort of the same things I was talking about. Do we have security audits? Do they look at our physical and network security? So they will either stake through a CTP, right, to us, through a platform like Coinbase Prime, for example. Or we'll see the CSA and CIRO have not been concerned with anybody using self-custody. Again, a lot of the big financial institutions don't do that for purposes of offloading risk, right? They prefer to use a custodian or a qualified custodian so that they're shifting the liability there. And that hasn't really been an area of CIRO concern or CSA concern. And I think lastly, in the US, they have been focused more on like staking itself. And what was really awesome, really great for us, we were celebrating, dancing in the streets basically. On May 29th, the SEC's Division of Corporation Finance set out guidance that said so clearly that what we do, which is protocol staking, not DeFi lending that we'll talk about later, not any pooling of assets, but protocol security is not protocol staking is not a security. Right. And so they laid out for everyone, and we saw a lot of institutional interest in staking after that. Again, we're looking for it to be codified in the market structure bill that's upcoming, on hold due to the shutdown. But we know that's coming in the market structure bill, right? And so we haven't seen this in Canada, but we've seen very clearly from the US that the SEC doesn't see it as a security.
Yeah, it's an interesting read. And maybe what we'll do, Tim, is we'll send you a copy of some of these materials that we're referring to, including there's two guidance pieces from the SEC. One is from May on protocol staking, as you're mentioning, Emmy, and then there's also one on liquid staking.
Which I did not even touch upon. That's a whole different thing.
Yeah, the analysis is quite interesting because when you read it, at least under the protocol staking side, we get back to this really tricky test called the investment contract test and whether there's a security. And as I say to many, reasonable people will reasonably disagree as to whether the elements of that test is met. But what the SEC explained in their notice is that, well, to the extent that it's a four-part test, like, is Emmy giving me money? Is she expecting a profit, which is a second element? Is she relying on someone else's managerial efforts to generate that profit? And is this all then fourthly part of a common enterprise? They said that under staking, one element that is failing under that test is that somebody who is staking is not deriving their profits based on the managerial efforts of others. They're instead sort of engaging in an administrative or ministerial service to the network and are being rewarded for that. So it's not part of this broader effort that would engage the investment contract test in Canada, in the United States under Howey, or in Canada under the Pacific Coast Coin case. So really interesting read on that particular pronouncement. But let's maybe move in the interest of time to stablecoins, if that's okay. So these are really considered to be one of the first killer apps or killer applications for the blockchain industry, just like how web browsers or email were some of the first killer apps for the internet. And so maybe, Kareem, over to you. Like, why is that? Why has there been such growth in this area? And we're now hearing about stablecoins all over the place. And I think you sort of mentioned it in your presentation what the banks are doing in this area, but maybe if you could just highlight a little bit more on that front.
Yeah, certainly. I think when it comes to blockchain, for the longest time, we always saw it as or not all of us, but many people saw it as a solution looking for a problem. And the reason why we haven't really seen killer apps for quite a long time was because the technology just wasn't very effective. It was slow, it was clunky, it was hard to use. And for that reason, we really didn't see critical massive usage when it came to any use cases. But today we're seeing a lot of use cases in payments. And leveraging the faster, more performant networks, you can get transactions that are fast and cheap. And because there was global demand for stablecoins in the digital asset and crypto trading world, there's now liquidity for stablecoins all around the world, which means you can take a US dollar stablecoin, you can trade it out for a local currency in hundreds of different countries. And so for a reason, for those reasons, now there's real utility, especially in cross-border payments. You can take a stablecoin from country A, buy it with the local fiat, transfer it to country B, off ramp it into the local fiat there, and settle it over the last mile rail within the local banking system into a bank account. And it can all be done in seconds and cost very, very little money. And if you cross compare that to the traditional financial ways of sending payments globally, sometimes it can take several days. It can cost several dollars or dozens of dollars just to enact a simple cross-border payment. So people see this as really just new financial rails that can speed up payments in general. Now, the first use cases that we see typically revolve around the use cases that we're familiar with, peer-to-peer global payments. But what's really exciting about stablecoins is that they're built on these open source rails, and they can re-engineer and replumb the financial system in ways like that we can't even imagine yet. So you can think about embedding finance into more and more payment use cases. Well, now firms that are not necessarily financial firms that leverage payments in their applications today can embed the tools necessary in order to facilitate payments in their apps. So you can think about firms like Uber and how they pay out their drivers, or YouTube and how they pay out content creators. They can now embed those rails into their operations and their platforms, leveraging this new technology in ways that are more deeply integrated than they can with traditional financial systems. And so I think with disruption, we often see the use cases we're familiar with come out first. But because of the open source and flexible nature of this, there are going to be new ideas leveraging payments that we can't even imagine today, much like there were use cases of the internet that we could not imagine in the first days of the internet.
No, that's great. And so on the legal front, though, there's been a ton of legal controversy over stablecoins, including litigation or threatened litigation. We've seen that in the US, Canada, and then there's been a lot of policy debate on stablecoins, whether they're securities or not. I'm not sure, Laura, whether you can maybe somewhat highlight a little bit of that, including we've seen in the United States a lot of discussion about this thing called the Genius Act. And we're seeing the development of a bit of a divergent position here in Canada, not a bit, quite a lot. I was just wondering if you can maybe take the adjudicators through that.
Sure. And it does link back. So the difference between the US and Canada today link back to the platform-centric approach that I have described earlier of the Canadian securities administrators. The CSA noticing the use of those stablecoins on platforms that they were already regulated by them as restricted dealer or as dealer under zero, and the rise of stablecoins and their uses, and the fact that they were not included under the Retail Payment Activities Act or under any other act, took the position that they could adopt a staff notice, imposing upon the crypto trading platforms certain restrictions and requirements if they want to use stablecoins on list stablecoins on their platform and allow their users to trade in stablecoins or exchange stablecoins. So what that led to is an interim approach that allowed existing stablecoins already listed on CTPs in Canada to file an undertaking according to which they would submit to the jurisdiction of the securities regulators and comply with certain requirements. That do include some it's not collateral, but some, reserve requirements and disclosure requirements are included in this. And in the interest of the one and only stablecoin that was already listed on these custodial CTPs, the issuer of it did file an undertaking and did submit to the jurisdiction of the securities regulator. It was quite a controversial thing to make happen, but I think everyone was very satisfied with the fact that we kept a stablecoin on custodial crypto trading platforms, which was the goal. But then moving forward, the US hopefully will bring regulatory clarity, and that was the Genius Act that you mentioned was very supported by the crypto industry. And in order to clarify that stablecoins are a payment instrument, they are not, and that they're not securities, and not a commodity, really treat them as a payment instrument and introduce prudential regulations. So very clear one-to-one reserve requirements with safe and highly liquid assets, such as treasuries, reserve segregation, audit requirements, and the requirement that the issuer cannot pay interest or yield to the holder directly itself. So that's the really bespoke banking payment system framework that the US has put into place. In Canada, we are still currently under this the securities regime only, and we have advocated for a federal regime for stablecoins that would clarify the issue and also make it possible for it to be used as it's supposed to be used, which is a payment instrument, rather than really treated as a security, which makes most of the uses we would look at almost impossible. I mean, if this is a payment instrument, you can have a debit card and spend it at a retailer, which is not currently something that is possible. Other use cases that we hope to see coming, and I hear what you said, Karim, but I think one of the things we also hope to see coming is more wholesale uses. And so the big transfers, intra-banks transfers could be done faster, safer with stable coins. And that's also something, if we keep on treating this as securities, this is obviously something you can't have. So it's still in developments. I think everyone is very focused on potential federal developments coming in and clarifying the regime.
Yeah, I think, the crux of the matter is that when it goes back to what you were saying at the beginning, Laura, which is that if you have something, a token that is ultimately characterized as a security, there are so many consequences that then flow from that, right? Do you have to issue a prospectus? Then are there trade restrictions on it, et cetera, if you're taking advantage of some exemption or what have you? And so fundamentally within this community, the blockchain community and elsewhere, one strong sort of vociferous position that they've put forward is that, this token, the point of it and the reason why people use it is that it's not like they're trying to profit. Ultimately, a stable coin, its value is stable. Like that's the whole point. So then how do we anchor it under the jurisdiction of a securities regulator? And where the fight has been is that the regulators will say that, well, no, we believe this is captured under the investment contract test, under our securities laws, or otherwise it's captured as a derivative. In the United States, under the Genius Act, as you were properly saying, they've clearly enunciated there that these payment tokens or these stable coins that I was just describing would be captured by that legislation and be regulated under that legislation. And the securities regulator sort of in parallel made it clear that they're not seeking to regulate this under securities legislation. And so what we have been hearing, and again, I don't think I'm speaking out of turn because there's a lot of press articles out here, is that it appears that the federal government may in the next budget come out with potentially some movement on stablecoin legislation at the federal level, which is exciting for the crypto community. I know that we have only 5 minutes left, Tim. So did you want me to move to the next topic on DeFi, or did you want us to take some questions? I'm in your hands.
Yeah, thanks, Usman. I don't have any questions at the moment, so please go ahead.
Okay, so let's perhaps just maybe move to the topic of DeFi. And Laura, you were sort of discussing this earlier, but Coinbase has recently done some big plays in the DeFi space. I'm not sure if you can maybe explain what some of those are and why this is so important to your customers. And you were talking about earlier about this issue of like custodial or non-custodial, because DeFi is supposed to be decentralized. Like, why should this be regulated differently? And I think you were describing it earlier, but just to maybe put it back to you.
Yes. Well, to be clear, our view is that crypto is meant to be decentralized. The reason why there are centralized platforms is to make it more simple and in order to bring 1 billion people on chain, which is the ultimate goal of Coinbase. But once it is easier to use the actual real promise, which is your own assets, your own custody, 24/7 usage and access to the assets that you want to buy 24/7, it is in the decentralized world. So yes, we've done and a lot of other products are coming in Coinbase, not in Canada, unfortunately, but in other jurisdiction where it's regulated differently, that do allow these types of products to be introduced. That's correct, that there is a lot being done in the space. The reason fundamentally why it's regulated different, as I said, I think earlier, is it really is that the risks are not the same one. They're really operational rather than custodial. So it is you're not addressing the same risks, so not looking at the same types of regulations.
Yeah, and then Emmy and Kareem, you sort of on this issue of custodial or non-custodial and why regulation maybe should be applied differently in that circumstance. You folks are sort of at entities that are on sort of your operations. Like one is very custodial, very centralized, being a bank, and then the other, as staking as a service provider, you're really offering a non-custodial offering. And so maybe I'd appreciate your views on that, on the different type of regulatory treatment that should apply on that issue.
Yeah, I certainly hear what Laura's saying, and there is certainly an operational element to interacting with these DeFi protocols. In the end, I mean, the ultimate goal is you want to reduce consumer harm. You don't want people to take part in protocols that would ultimately lead to some kind of harm. And I think there's several DeFi protocols that have proven themselves to be quite battle tested, quite trusted, and quite robust. But there have been DeFi protocols that have coded in the opportunity for the creators to rug pull and take advantage of certain people. And it takes a certain level of sophistication of a user to be able to interact with these protocols. And so I think that the technology holds a lot of promise, but it also is quite a sophisticated technology that not everyone is really quite well equipped to interact with. And for that reason, it leaves open a lot of room for abuse. And so to wrap our arms around that, I think should be a priority in order to reduce as much harm as possible. But that shouldn't necessarily get in the way of innovation for the protocols that do hold a lot of promise and have proven themselves to be quite strong and robust. So yeah, it's a fine line to walk for sure.
I mean, I don't think I have much to add, right? I agree that we have to figure out some sort of balance between harm reduction, right? But not just slapping bank type rules on these decentralized platforms, because that doesn't really make sense. And at Figment, we operate very much in the non-custodial area. We obviously aren't a DeFi platform. We don't do any of that DeFi lending, but because we never take custody of our customers' assets, we are able to operate like outside of various regulatory regimes, like in each of the jurisdictions in which we operate. So it's something we feel strongly about as well.
Okay, so with that, seeing also the time, I'll maybe throw this back to Tim.
Great. Well, Laura, Karim, Emmy, and Usman, thank you so much. That was a really fascinating discussion. I'll be watching closely for any stable coins cases that are, where there's a dispute about that coming. I just did a quick check for the BC and Alberta commissions, and I haven't seen any cases about that. I don't think we've had any in Ontario. Usman, I don't know whether you know that that's different, and presumably we'll see whether something comes. Usman, if you would be kind enough to send me at some point the guidance, the US guidance, the two things you were sending or mentioning, I will pass those on to the big crowd. But again, Krim, Laura, Emmy, thank you so much for a great discussion. Really appreciate it. Usman will be back in half an hour after our break because he can't get enough of us. So we will now take a break until 1 o'clock Eastern, and we'll see everyone back here then. Thank you. Back. Right, that too. We're back from the break. I hope you enjoyed the break. Just before we move it over to our next panel, just a quick note about the chat. The Zoom chat continues to give us some challenges here. As some of you have noticed, if you have a question, you're unable to select me, most of you, all of you, select me as the recipient. So if you don't mind, the few of us hosts and panelists, there aren't very many of us, seeing who asked the question, please just put it in the chat to hosts and panelists. I think our panelists probably aren't keeping an eye on the chat anyway because they're busy talking to us. If you don't want anyone other than me to see who the questioner is, who you are, just send it to me by email, please. And I'm keeping an eye on both. So thank you for your patience and understanding with that. So we're on to artificial intelligence. And now your first quiz is to figure out whether Usman is a deep fake or whether that's really him sitting in his office. I'll let you all be the judge. And with that, I'll turn it over to Usman to introduce his panelists. Thanks. Take it away.
Okay, that's the first time I've been called a deep fake, so I'll accept it. Thanks for having me back. We once again have
that's just what a deep fake would say. Anyway, sorry, I'm
out. So thanks for having us for this panel. We have once again a really spectacular panel of speakers. Really honored to be speaking here with both of them. Our first panelist is Costa Starostin, who is Vice President Legal at Cohere. Cohere is a large AI model provider, and we're going to talk a little bit about what that is in a moment. Probably heard a lot about Cohere in the news as one of the most prominent Canadian AI companies. We also have Veer Siddiqui, who is Director of IP and Commercial Services at the Office of the General Counsel for the TMX Group, which, as you may know, among other things, operates one of Canada's largest stock exchanges. So we have a half an hour for this particular panel and a lot of topics to cover. So perhaps let's just start off with some basics. Veer, Costa, again, thanks for joining us. The adjudicators have been hearing a lot about AI lately, and perhaps they're even maybe using AI tools themselves. I don't know, maybe Veer, if you can start us off by just giving us a high-level overview of what AI is.
Oh, I'd be happy to, Usman. Thank you, obviously, for having me and, Tim and the rest of the team. It's a pleasure to be here. On the deep fake issue, Usman, I think you just have to take it as a compliment. It means you're just too good looking to be real, right? Like it's the only explanation, right? But turning to what AI is, I think that it's quite rightly, there's a lot of buzz, obviously, in the news right now. And what I always like to start the sessions off with is sort of reminding everybody that in some ways AI has been around for a very, very long time. And there's a lot of related terms that get bandied around. And so what I always like to emphasize is this idea that, the analogy I would use is almost like a series of Russian dolls, where, AI is the largest component, and it really is just the broad sort of 60-year-old concept of attempting to use technology to artificially copy human-based like reasoning and human-based tasks like reasoning and problem solving. That's your biggest bucket. And within there's a wide variety of techniques. And there's another little tiny doll. And one I think we probably hear a lot about in this world is machine learning. And that's sort of a subset of artificial intelligence that sort of learns from data rather than being explicitly programmed deterministically, like do this, then do I, then do what. So it learns. And that's probably the largest and most popular technique of artificial intelligence to date. And, I'm sure Costa and I will both be talking about some applications of it later on. And then I think the one that's been really generating a lot of the buzz lately is a subset of machine learning. That's the smallest doll inside there, which is generative AI. And so as the name suggests, that's a scenario where you use techniques of machine learning to not only learn from large amounts of data, but then to produce new content instead of just predicting or classifying data. The point is that content should somehow be close to or copy the data that it was trained on. So you have those three different concepts. And so the one takeaway I would want everyone to remember is that, you know, all Gen AI is machine learning and all machine learning is AI, but not the other way around. And each one of those different concepts comes with its own benefits, its own challenges, its own risks, and its own specific use cases. I think another thing on AI that I'd like to sort of emphasize is a lot of times we'll see a piece of technology and we'll be like, that's AI. But actually, most solutions are made up of multiple layers. And you know, where I think of over here, the picture that I like to think of in my mind is sort of a production line, where you know you put the whole thing together, and that produces a product. And in this case, you know, you always start with your power plant, and that would be your hardware and your infrastructure upon which your technological solution is built. You know, it provides the energy. And you know, then you might jump into you know your foundational model, which would be sort of a general purpose engine that's coming out of that factory. And like an engine can power a lot of different types of vehicles. It's not quite yet specialized yet. It just brings a lot of power, a lot of horsepower to the solution you're trying to build. But it's not really useful until you run it through your custom machining or your workshop to produce now a specialized tool or specialized you know, robot or engine or car. And that would be sort of, in this case, that would be the fine tuning of your model, your AI model. And that would be that layer that comes into place over there, the custom workshop. And then finally, you know, you'd produce your final machine. And that's sort of specialized. It's no longer just a general engine. It's custom built race car. It's a specialized diagnostic tool that's really built for one purpose. And then finally, obviously, you know, we don't interact with every part of our car. We just deal with the steering wheel and the rest of it. And that's our user interface. And so when you look at each of those layers separately, you'll come to realize that many of those layers, the power plant, the workshop, all that, those have been around forever and they're used all the time in a very deterministic way. A lot of the issues that we talk about when we talk about AI are really in those top layers. And I think that's where the really new buzz and new interesting edge cases come from. So, you know, that's
Okay.
how I like to sort of explain it.
Yeah, no, that's really helpful. So the adjudicators, Costa, are going to hear in what Vera was describing about AI, about a lot of different actors that form part of that production line. And it's going to come across their hearing rooms. Maybe if you could just describe who are some of the key actors in an AI ecosystem. I mean, you folks are an AI model provider, but I wonder if you can just add some further context to that.
Yeah, absolutely. And great to be here. And if you notice the light is a little bit odd on me, it's because I'm in my car right now. I had to take my 4-month-old to get his vaccine. So he's off doing that fun task, and I'm here with you all. And again, thanks for everyone for inviting me. Yeah, so as Usman mentioned, Cohere is a foundation LLM company. I think Vera gave a really good overview and a really kind of helped us in the way when we explain AI to folks, it really helps to ground them in the fact that this technology has been around forever, and that there are rules and kind of industries that have developed these rules and rules of the road for a long time. And so while it's novel and unique, there are a lot of similarities and commonalities, and it is built on top of decades of kind of innovation. So it's very important to kind of keep that in mind. And I think the one add I would make to what Veer said is that Gen AI is the biggest driver of interest in industry right now because it sparks the imagination. There are so many different things it could be used for, but the landscape of what AI can be put for is quite broad. There are embeddings models, you know, there are different kinds of models that do different sorts of things. There's search and retrieval. There's now retrieval augmented generation, which grounds results in verifiable data and tags it. So it has quite a bit of complexity in the space. As far as the players go, again, very, very kind of apt analogy. I think you can think of the NVIDIAs as like the hardware chip manufacturers. They are really the folks who build the GPUs, the TPUs, the compute that powers all of the computers that are train the models. So in a typical AI process, what happens is you use a lot of compute power to train a very, very large model on, you know, billions or trillions now of tokens, which then allows you to create or essentially like a mathematical representation of probabilities that tie to certain results. So it's a lot of it is predictive. If you have these sorts of permutations, like what is the likelihood of this being the next word, the next sentence, and words are typically clustered into small bunches. They could be one word, they could be a segment of words, and really ultimately at its core, machine learning is mathematical probabilities that kind of layer on top of each other to then train a model. So there are the NVIDIAs of the world, the CoreWeaves of the world who build the hardware. There's one layer below that, which are kind of obviously the folks who manage the build outs of the data centers. They make sure that there's proper power supply and everything else. There are then the model developers like Cohere, some of the other ones you may have seen, OpenAI, Anthropic, who build a foundation of models using those chips and those hardware. There are then additionally application developers who would take an LLM. In our case, Cohere is purely B2B, so those would be enterprises. They would then use our model, integrate it into either their own existing workflows or into their products that they then pass on to consumers. There are people who play across different spheres. So in Cohere's case, we are a foundation model developer, but we also do have an application called North, which is basically like an agent foundry. And we could talk about what agents are in a little bit further down the line. But if you think about it, there are kind of the chip manufacturers, the hardware folks, there are users of AI such as Cohere, there are people who develop it. And then there's the last big cluster, which are the compute providers, the cloud providers. So those are folks who both sometimes are in both camps where they are the ones who rent or lease these GPUs to build these mega factories. There are also folks like, the Googles, Metas of the world who provide cloud or Microsofts and Amazons who provide cloud infrastructure that allows you to deploy the models. So for example, if you're accessing LLM, you may not want to be able to, build or train your own data center. You might want to have your own hardware. So really you need those folks to be able to access the hardware. They'll lease it, they build it up. You can access and power your applications by accessing those sort of cloud providers. So it is quite a dynamic ecosystem. And every day we see more and more niche players enter it that target specific things. Like there are now companies that focus specifically on efficiencies in a certain part of the tech stack that allow you to gain, certain either capital efficiencies or competitive advantages. And of course, you'll see thousands of application builders that utilize AI for consumer or business products.
Okay, no, that's really helpful because I want the adjudicators to start hearing some of these terms, and they may not have understood all the terms in great extreme depth, but it's important that they understand how the ecosystem is built and the hardware and other components sort of work together. So that's really helpful. Let's take a quick look at some of the industry developments before sort of diving into some of the issues here. The AI industry is really moving a mile a minute. So the adjudicators may have heard of, like, for example, Sora, that has this remarkable text-to-video generation tool to create these lifelike videos. And then you referred to these AI agents or agentic AI that has become now all the rage. Can you give the adjudicators a sense of what you're seeing, some recent industry trends or developments in the AI space generally or in the capital markets area? Maybe Costa, I'll start off with you and then over to Veer.
Yeah, absolutely. So as kind of Veer mentioned, the progression we've seen are, old school AI, which is just very kind of simple. Now we would call it kind of dumb compute. It just does very simplistic calculations. It tries to predict probabilities. We've moved from that to kind of large language models, which are much more complex. You could think of them as like neural nets, and I won't get into kind of details, but essentially they create very complex representations and then again are used in much larger quantities of data to be deployed. We've moved from that to sort of very tailored models. So whereas we used to have large language models that are very general in scope, what's happening now is that you can build smaller models that are specific to a particular use case. Obviously, you trade off because in building any sort of model, the bigger the model, the longer it takes for it to process, the more compute it absorbs. So there are trade-offs in the industry. You trade off latency, for example, versus cost versus the corpus of data that what you need. And so there are models now which are not just like the largest model, but they're specifically targeted for a particular use case. So they'd be trained on data that, is in the financial services industry, if they're used for those cases, which helps avoid hallucinations, as you may have seen. One of the kind of prominent issues in AI has been hallucinations, and that is a feature of the industry. It's not necessarily a bug because you do want the models to come up with an answer. Models can't not answer, so they'll keep trying and try to figure out an answer. But when you have models that are specifically tailored for use cases or industries, that allows the developers to train with a more specific subset of data. So you're not kind of taking all data in the world, because you don't need the model to answer questions about, vacation travel plans if you're building a model that's specific for a particular industry. This allows much more refined, cost-efficient models, smaller models to be deployed, eventually models that will no longer require, vast amounts of compute, but could potentially run an architecture as small as your cell phone. There are models of that size now. They can be used, fairly quickly. Of course, as I mentioned, the capabilities are quite limited in what those models are. The next step of that evolution is what we talked about briefly, which is agentic AI. So whereas you can think of classic LLM as user interacts with model or interface, prompts it, it gives them a response, like ChatGPT, I think we're all familiar with. That is the classic kind of use case of these models. Agentic AI is really the next step of that, where you build something, an agent that is an AI agent that can not just take prompts, but it can think of what to do next. It can create its own, workflows. It can ask questions that you don't have to prompt it to ask. So for example, you can give it some direction. You can create an agent that would essentially mimic what a worker in a company would do. And it can think like a worker to take the next steps. It could say, hey, we should probably send out an email about this. Here's what I'm thinking of drafting it. It can contact other agents. If you have different agents in the company, agents can talk to each other. Agents can talk to human beings. So there is a layer of abstraction that's now happening, where you can think of the agentic AI pieces as really just being the next step, where machines can kind of talk to each other and undertake very complex transactions, very complex steps. Now, I will say that the bulk of where all of this is still landing is in areas where there's structured data, where it's very clear what you want the outcome to be. Models are really good at those things. If you have clear direction, if you have clear data, if you know what it needs to do. So for example, if you're processing claims or administering, patients at a hospital, a model will do a really good job of that. It'll do a really good job in procurement, where you kind of know what the budget is, what you need to buy, what resources are low in stock, for example, and when you need to reorder them. They'll be really good at that. Where what models can't do, and it's important to remember, is they're not always going to be good in creative thinking like human beings. Like they won't necessarily think of uh, potential opportunities or directions outside of their kind of framework. So like a human being could think of, okay, we've done this for this process for a number of years, but we could also think about something completely different. A model will have a hard time necessarily being subjective and abstracting to move outside of its kind of parameters, unless you kind of prompt it in the right way. So there is kind of that's tier, but I think the development has so far been moving towards those agents, and that's agentic AI is kind of the precursor to what you may have heard us call like AGI, which is really just artificial general intelligence, and that's still a far off. I think it's still a far off goal, and there's shifting definitions of what AGI is. And some people have said it really was what OpenAI or Microsoft determined AGI to be, so it kind of gives you a flavor of like nobody really knows when you've crossed that. But the idea being that at some point the agents are very autonomous and require very little intervention or prompting in order for them to kind of basically do the tasks that a junior associate in a law firm would do, an accountant would do. They could basically run the entire function from start to finish with very minimal intervention. They can create contingency plans if things don't work quite right. Again, with the caveat that something that's very subjective or requires abstract thinking would be probably beyond the scope of some of these for a little while.
Yeah, your comments are inspiring all of us to seek early retirement, but maybe veer over to you to just elaborate on any other use cases that you're seeing, and maybe also discuss any of the thorny legal issues that are sort of arising with this as well.
Yeah, no, sure. And I think what I really appreciated of Costa's introduction, because I think it highlights one of the key things that I think our adjudicators are going to see. Like, there's trade-offs in every application and implementation of AI, right? And I think some of the terms are going to be seeing a lot of, Costa already mentioned retrieval augmented generation, or RAG models. You're going to be hearing that a lot. And you'll also be hearing the concept of grounding, which is really how do you take a model and reduce the probability of it going off on its own and hallucinating something. And so in the capital markets context, I think what you'll be seeing is AI has permeated almost every part of, really, I'd say, like every part of operations. And what you'll see is the trade-offs. So you may have some use cases where I know, for example, we have teams that are now in terms of business accepting when we produce out new features and tools, where obviously those new features and tools would have to be tested from a business perspective. I'm setting aside code generation and DevOps. I just mean literally from a business analysis perspective, wanting to make sure that a user interface or for one of our trading partners works exactly the way it was supposed to. That would typically require a lot of time to generate test cases and walk through all of that. We can leverage Gen AI to help us write those test cases, come up with hypotheticals. What are all the different ways a trading partner might try to break this system? And let's test and make sure it's not throwing up an error. So writing out those test cases, collating that data, making recommendations, that's a very, I would say, is a very creative use of AI that hits market operations. But then you also have, other examples where now you're leveraging much larger data sets. Something that comes from home is our TMX's quote DK signal, which sort of uses traditional, well understood machine learning, using a decision tree and analyzing live market data combined with historical data to help predict when a quote given on a particular stock might be decaying soon, and signaling to a trading partner that they may want they may want to execute on their strategy. And so we might not think of that as the new sort of sexy type of Gen AI that's happening, but the reason I offer that to you is because it sort of shows that the sort of traditional machine learning that follows very clear deterministic pathways is still an application of this, and I think our adjudicators will see the whole range of those. We're also then seeing more interesting things in the marketplace, we have actors. I believe like the team at NASDAQ is actually introducing, Gen AI powered features for surveillance tech to help triage and investigate market abuse. You're also seeing other actors are introducing now tools that can conduct sentiment analysis, analyzing tons of social media to help predict how things are going to work in that respect. We're also having, and we're doing this to an extent as well, other market actors are sort of using AI assistance to help clients and market participants navigate complex rules and policies. So, whereas maybe I or other in-house legal departments would be getting tons of questions, now there's ability to provide sort of a preliminary, self-serve tools to people that are using that RAG technique. And RAG would just be is the question will pull from our large body of knowledge to answer questions, in a more human way. Really try to understand the intent behind the problem and provide a result in a more organic way than I think we're used to when we call the bank or something like that. And having a little bit more flexibility there is, I think, providing us with opportunities in every different part of our business.
No, that's really helpful. So I'm hopeful that my screen is being shared, because what I wanted to just show the adjudicators is that first of all, the Ontario Securities Commission, to their credit, have a pretty good web page on AI, which has a lot of very helpful resources. And so I'm going to send this link in the chat and also to Tim, but you should feel free to take a look at it. And two reports that you may want to have as some bedtime reading is this one here, AI in Capital Markets, Exploring Use Cases. And so if you were to click on that, it's a report that was issued in October of 2023 by the OSC. And this is the full report here that was done with EY. And it looks at all the use cases in the capital markets that are developing. And so it's a very lengthy report. And you'll see here that the most mature use cases were identified as AI uses for improving the efficiency and accuracy of operational processes amongst capital market participants, trade surveillance, detection of market manipulation, using AI to support advisory and customer service. This is where, based on that report, they were seeing most capital market activities, or at least the most mature projects by capital markets participants being done. Another really helpful report, if you scroll up, is this one here, CSA Staff Notice and Consultation 11348, which is over here. And then this is the PDF version. And it will highlight a number of the very thorny and challenging legal issues, including securities issues, that have arisen when you're looking to apply artificial intelligence with capital markets initiatives. And so have a read, because a number of these issues may land on your desk. Things like AI governance. I mean, very, very different governance mechanisms that, let's say, an investment dealer has to have in place in order to deal with this new thing called artificial intelligence. Things like having human in the loop, or making sure that you're addressing unique cybersecurity issues that arise from AI. Same thing with explainability. If you're having a requirement under securities laws to explain your decision, including on, for example, suitability of trade, how do you do that with an AI model that may have less explainability, or may be considered what some refer to as a black box? I'll just also submit this in the chat as well. An interesting case that arose and that was demonstrated at the UK AI Safety Summit in 2023. And this was a report by Apollo Research that tested in a sandbox environment whether a particular AI model would take illegal actions like engage in insider trading and then lie about its actions in an attempt to deceive its overseers. And in that case, the AI bot was sort of trained to basically provide investment management services. A client, told it that it needed a good quarter, and it ultimately ended up trading on insider information and lied about it. And so you could see some of the conclusions here, but the report notes that this behavior occurs consistently, and the model even doubles down when explicitly asked about the insider trading. So interesting developments here. I know that I see Tim on the line. Are we at the appointed hour, or?
I was going to try and squeeze in a question if I can, if that's all right. Unless was there something else you guys want to really make sure you hit, because make that a priority?
Just maybe one point, which is to say that on the litigation side, particularly on the enforcement side, which is what the adjudicators will be dealing with, we have seen historically a lot of AI washing cases. This is where a company is basically making false or misleading statements in relation to its AI capabilities or some tool that it may have, and maybe raises capital. We've seen a lot of a decrease in that in the enforcement context in the United States, particularly with the change of the administration. That said, and I'll send you the link to this as well, Tim, there was a case that was just brought in April involving Albert Saniger, where this is under the new Trump administration, and everyone was wondering where they might go on enforcement. And this is another case where an individual said, oh, well, this is AI inspired. And meanwhile, everything was being done manually by some contract workers in a foreign country. And so there's now a prosecution by the SEC and DOJ. So all to say that when it comes to fraud, that type of enforcement action, we see it continuing in the United States, and we're still waiting for the first few cases here in Canada. So maybe I'll just pause there and see if there's a question.
Thanks. We'll try and squeeze this out. I have one question from an attendee. I'll quote, "What steps, if any, are being taken by markets and or regulators to curb AI's amorality?" This is this agentic misalignment in the tech speak, right? But is there anything? Let me rephrase it a bit. Maybe is there anything markets and regulators really can do, or is it all in the hands of the developers of the models?
I mean, I'll maybe start off, and then I welcome comments from the co-panelists. But what we've been seeing, if we were back on the crypto panel, one thing that we saw is that guidance in this area didn't come for many years. And again, I don't fault anybody for that, but the Satoshi white paper came out in 2008. And the first guidance that we saw from any Canadian securities regulator, and frankly, any US one, was in 2017. So almost 10 years after, a lot of these projects were up and running, and then they're not sure about the application of the laws and how to curb some of the problems that may be arising in the area. And I think that that's what some regulators, including the CSA, have been trying to do with these reports. This whole report goes sort of registrant or capital markets participant by capital markets participant, saying, if you are to apply AI, I mean, we have some legal issues or other governance issues or others that we need you to turn your mind to. So I think that this guidance has been very, helpful. And I can tell you a lot of our clients have been reading it with great interest and applying some of the strategies or thinking behind it. I don't know, Costa or Veer, if you have anything further to add to that.
I agree with everything you said. Guidance is obviously always helpful. I think the goal, if it go to questions of like what we can do and what others can do, I mean, at least, I'm not a TMX spokesperson, so I'll be advising it sort of as, my position as having sort of been in the industry for a while. I think what's really most helpful as, combining us both as actors and regulators is to really be asking, on a principled basis, how can we take a look at the core principles that have always been there around explainability, avoiding fraud, things like that, and ask, what's changing, if anything at all, and what guidance can we give on applying that through the lens of proportionality? I think that's it. So I think the two things that would really help maintain is remember that it's not so much as changing what, like we should continue to focus on what it is we care about maintaining: safe, efficient, innovative, and competitive markets, not so much, really shifting into the how and starting to prescribe specific techniques for how we address those. And then I think the second thing that we can do as as participants and potentially regulators is helping to think about this through a risk-based approach around proportionality. Like I think the things that we'd be looking for in terms of things like explainability that Usman raised, over something that's like a back office implementation of AI versus something that's trying to give financial advice to retail investors. I think those standards should be a little different. And I think we should keep those ideas of proportionality into mind. And then the third point, I think probably the final one is to maintain this open dialogue and have it happen earlier. As you said, we don't want to wait till 10 years. So I think that those are the three things that I would probably suggest. And maybe the last thing I'd say that, like, certainly the principle that Usman mentioned is one that is a core guiding principle for us in all, and certainly me in all my practice and over us at TMX with our AI program, which is really always asking about, where's the human in the loop? What are the core risks here? How are they being mitigated? And keeping that front of mind in all of our implementations.
We should probably.
I know we're at time.
Oh, sorry.
Sorry.
Probably should give Costa the last word here and then wrap up.
Oh, perfect. Yeah, I know we're at time. So thankfully, Veer said a lot of what I was going to say. I mean, I think the first principles of proportionality are top of mind. So the last thing I'll just leave you with is what we can all do is probably use the technology more and experiment with it. Like there are a lot of applications you can use that are very low risk. You can deploy it in enterprises in a very safe and secure environment or safe, secure manner. I think the more you actually understand how the technology operates, what its limitations are, you work with it, the better you have an appreciation of how these issues might arise, how the technology might evolve. That we found that to be the most effective tool in the enterprise space, and I'm sure that translates the same for the regulators.
I from my amateur's perspective, Costa, I think those are very, very wise words. I've trying to push that where we work, and I think it's one learns a lot by playing with the toy, so to speak. I mean,
Exactly.
even outside the work context, and we understand what the limitations are and what its strengths are, and so on. So that's excellent. We could spend hours on this. It's a fascinating topic, and Veer and Costa, especially the level of commitment while your 4-month-old's getting a vaccine to be here. I really appreciate all of your participation in this. That's a really great discussion. Thanks for your time.
Thanks for having us.
All right.
Thanks.
Thanks, guys. Thanks again, Usman, for shepherding both of those panels. That was great.
No problem. Thank you.
Good. Thanks. All right, we're going to move straight on to our other returning champion. Usman was one of them. Nizam Kanji is our other returning champion, back with us for the third year, leading a panel on takeover bids and shareholder rights. Nizam and team are all in the same room on this one, so we're going way off the historical scripts here, and this will be much more exciting for the dynamics. Good little brawls back and forth, I hope, or fake ones anyway. So to talk about takeover bids, shareholder rights, and associated issues, I'll turn it over to Nizam. I'll say thank you very much to all of our panelists in advance. Turn it over to Nizam to introduce his panel. Please take it away, Nizam.
Thanks, Tim. And it is different, but we are hoping that will make for a very interesting, candid, informal, and informative conversation. So I want to start by introducing our panel of very expert and experienced M&A practitioners and a regulator. Karen Powles-Libby from Torys, Aaron Atkinson from Davies, who's also our host, Jeremy Freiberg from Osler, and Jason Koskala from the OAC. Their detailed bios are in your material, so I'll leave it at that, or else we'll run out of time. We're not going to be putting the slides up, so we can have this nice informal conversation. But you have the slides, and we can move to slide 3, and I'll just start with introductions. First, in terms of the objectives for a panel discussion today, it's really to get an on-the-ground perspective on M&A proceedings at tribunals, with a primary focus on the application of the public interest jurisdiction, which is the issue that is most commonly raised in front of tribunals and raises also some of the thorniest issues. And we're hoping when we get to some of the substantive discussion that we have time to also talk about joint actors, which is another very substantive issue that also is commonly raised at M&A proceedings. Our panelists will be providing their perspective on how they think about the choice between courts and securities tribunals, some significant M&A regulatory areas relating to the public interest and joint actors that have been addressed in the past, but we anticipate will continue to be of consideration going forward. And there may be twists on some of the cases that we've seen recently and in the past, so we'll talk about that. And at the end, time permitting, we're hoping to get each of their perspectives on the things that they think tribunals should be thinking about as they hear these matters, when they're thinking about the decisions they're going to make, and the reasons they provide to make them as useful as from the perspective of practitioners who have to advise their clients. So continue.
Yeah, sorry, Noizem, just one quick housekeeping note. It's clear to me now I misunderstood your comment from yesterday about the slides. So I've not distributed them. So just so you're aware, attendees don't have them. If you want, we can put them up on the screen.
No, so you know what? So in this case, I'll just go actually through the material. The slides are really more of a guide for us for our conversation. So
great.
No one's missing anything with them. So not a problem at all. So and the reason actually is what I'm about to get into is that today's panel builds on the last 2 years panels. As Tim mentioned, I've been involved for the last 2 years. It's my 3rd year. And the goal has really been to build on each year from one year to the other on the material that was from the previous year, the panel discussions. And the last 2 years, we provided a very detailed material on all the key areas of M&A as background. So this year, our goal is to really build on that and really have a more candid conversation among practitioners and regulators about all the things that you have in those prior materials, but also what's going on right now. So I will be using this, the slides just as a guide, and I'll be telling you where we are at any given time. So there's no need for the slides. So now to really get into our conversation, I'm going to first ask Jason, our regulator representative, to just summarize for us the scope of the public interest in M&A. So we're all on the same page as we start off in terms of the kind of orders and under what circumstances we see public interest issues.
Yeah, sure. So I'll just give a bit of the brief overview so we're all on the same page. Under the Ontario Act, Section 127(1) is the public interest provision, and it permits a tribunal to issue orders, if it is in the public interest to do so. So everything is about what does that mean. The public interest jurisdiction is animated by the purposes and principles set out in the Ontario Securities Act as well. And what's most powerful about public interest is that orders can be issued even where there is no violation of securities laws, where conduct is found to be abusive. In terms of remedies when parties are seeking an order under Section 127, typically in the M&A context, what you'll see are cease trade orders, requirements to provide or amend disclosure, or denial of exemptions, for example. Those would be the most common remedies. And applications under Section 127 can, as of right, be made by the Commission or staff, but private parties also can apply for standing and seek a public interest order. So in many cases, applications under 127 are brought by private parties, subject to the initial threshold standing based on jurisdictional and forum considerations and such. So the types of public interest applications we get in M&A fall into, a few relatively discrete buckets. One is that you can have applications seeking remedies in respect of alleged actual violations of Ontario securities law related to takeover bids, issuer bids, or the rules we have for conflict of interest transactions. But you can also have, or additionally have, allegations related to conduct that is contrary to the public interest, where there is no express violation of securities laws, but that conduct or that's in question is alluded to or referenced in guidance or other policies of the commission. So, for example, questions about defensive tactics and takeover bids, we have a longstanding policy on that, and so that may inform considerations of public interest or abuse in that circumstance. But you can also have broader conduct-related allegations that don't necessarily tie explicitly to an existing policy or guidance, and that could come up, for example, if there were issues arising in relation to a proxy contest or a mini tender, which is basically a tender offer that's not technically a takeover bid, or other novel situations. So it's quite broad, but those are really the categories in general. Lastly, I'll just mention there are a couple other ways in which the determination of the public interest in intervention could come to the commission, and that would be through an application for exemptive relief from requirements of the takeover bid regime, for example. And there are certainly cases where this did happen, because if you have a contested application for relief, that can go before the tribunal, and the test there, whether it's different or not, may be open to debate, is whether or not it would be prejudicial to the public interest to grant the relief. So fundamentally still centered around public interest. And lastly, in circumstances, the commission or the tribunal is the appellate body for reviews of exchange decisions. And in those hearings as well, the questions of public interest are pertinent, because if there's a different understanding of the public interest applied by the exchange versus commission, that could be formed the basis for hearing the matter de novo. And then if it is heard de novo by the tribunal, again, the decision will be informed by public interest principles.
Thank you. Thanks, Jason. So now, I want to open it up for a conversation about, why someone would be picking the tribunal relative to the court. And so, Aaron, I'm going to, put this to you. So M&A matters can straddle both courts and regulators. And that could be, violations of securities law, which there's a provision in the Act, Section 105, that allows someone to go to the court to get a remedy. But definitely public interest applications could easily, or at least, if not easily, at least be considered as potential oppression or breach of fiduciary duty conduct also. So, what considerations going to, whether to go to the tribunal or the court, where both potentially could be options?
Right. And it's a good question. And I think it's something that we consider in anytime someone comes to us and says something's just not right, what's the best remedy? And so, yeah, your choice is court or tribunal, often not both. Sometimes you can go to both, but there's also just the issue of cost and time. So why would you choose the tribunal? One is timeliness. Courts, especially in Ontario, I think are overloaded. It's hard to get on the commercial list. Not everything is as a right to get on the commercial list, which is our specialized commercial court. And so that, getting a hearing 6 to 8 weeks from now, justice delayed is justice denied. So that may not be in the cards to get a timely remedy, because this is M&A. You're in the middle of it. The clock is ticking. And so, there may be easier access to the tribunal. Another important one is the expertise of the tribunal compared to courts. Again, our commercial list has sophisticated commercially minded judges, but they don't have the level of expertise that the tribunal members would have. So you may feel that you get a better hearing on the true merits of the case as opposed to strict legal principles. The hearings themselves can be held quicker, often in a very speedy fashion. That can actually have benefits and drawbacks. But again, you're in the situation where days count, hours count, weeks count. Another important fact, I think, is that the evidentiary rules are quite different, or I'd say maybe more relaxed in the tribunal setting as opposed to the court. And then the remedies are also quite flexible. As you know, so we're talking about 127. Even the words on the page might seem kind of restrictive, but I think there's some creative uses of cease trade powers, and you're cease traded unless you do X, Y, and Z, so that you can address behavior through those means. And then another one that's important, I think, it's not a driving factor, but there's no cost consequences when you bring a matter before the tribunal. There's no chance you're going to get the cost of the other side awarded. I suppose that in some egregious case you could have that happen, but and then not to be to undersell the role of staff, right? Because when we're evaluating what to do, invariably we'll have test driven our case with staff, who in a perfect world take up arms for us, depending on the circumstances, or they'll give us their view, and obviously they will have a voice at the table, and that I think is important as well, to have that. It's not like a friend of the court brief, but it's obviously a sophisticated group that will have a view. So I think all of those together can very often drive us, recognizing neither form is perfect. Neither form will, in most cases, give you all the remedies you need. And I think the other thing to consider is when you do have a case before you, the parties, if they're not going into both forums, they will have had the opportunity to go to court, and they chose not to for some reason. And I think one issue, which I think I'll try to pick up on later, is as a result, one point, you've foregone a choice, and that choice may not be there for you. If you strike out at the tribunal, the court may not be there anymore from a timeliness perspective. And so I think recognizing that the parties have made that conscious decision to come to the tribunal versus the court, I think that should actually play into how you judge issues that may not squarely be securities law issues, but fiduciary principles and the like.
Okay.
Nice. I'm sorry. Just can I jump in just with a follow-up question on that briefly for Aaron? Would you mind just expanding a bit on your comment a couple of minutes ago, Aaron, about the sort of different approach to evidence, different evidentiary standards between the tribunal and court? I mean, I know kind of the legal structure looks a bit different at one level. I'm curious because I don't really have a good handle on what it's like in court these days. Right. Well, as a practical matter, is there a difference? I've always thought of the securities tribunals as having applied the rules of evidence fairly strictly in these kinds of cases and in a court-like way, but maybe that's wrong on it. So any light you could shed on that would be helpful.
Sure. I was afraid I would get called on that comment, so I debated many cases. So and this isn't to suggest that the evidentiary standards are low and you're letting in crazy information, but I think, for example, using hearsay in a tribunal setting might actually be more admissible than in a court where there's more strict rules. And so, not that you're trying to prove the truth of the facts that were said, but the hearsay evidence may actually be relevant for coloring the facts and the like. And I think also just that the evidence is also gathered in a much quicker period, right? Like if you have a poison pill hearing, that's done over 2 days, as opposed to a hearing where you've got scheduled cross-examinations in front of a court reporter. The evidence is digested. So even in that sense, I guess what I'd say is the fact gathering process, I think, is a bit truncated, and it forces you to kind of put forward maybe you leave a lot on the cutting room floor potentially because of the time truncation. So I'm not suggesting for a minute that you're letting in forged documents or anything like that.
You don't need to be you don't need to be defensive. It was a question just being on the hearsay point. Obviously I'm fully aware, as my colleagues are, that under the Statutory Powers Procedure Act, at least in Ontario, there's an explicit right for tribunals generally to admit hearsay evidence. But as a practical matter, I think that there's a lens of necessity and other factors that get applied to that. And my sense from a distance is that the courts have kind of got there too, is that they've relaxed a bit the strict rules of decades gone by about hearsay, and that they're applying in substance what's kind of a similar test. So I don't know whether that's true or not. But
so Tim, if I can jump in, I think that and I think it would be good to hear from Jason too. I think that definitely at the staff level, when thought is being given to, is this a corporate court matter versus a securities matter, one of the criteria we anticipate, the tribunal will consider in that, that's brought as an issue, is the court's lengthier and more how shall I put it, like the securities tribunals tend to be more surgical, they're policy oriented, they're focused on the issues, everything is tied to that. There might be matters that are more suited to the courts, which have, which will take longer bring a lot more evidence, and and so the nature of the issue may be more suitable to a court proceeding, and versus an administrative tribunal in a specialized one, which is going to move directly, and that could play to any party's advantage or disadvantage. But
yeah, I suspect that it's driven by the time issue. If you engage the court and you have the machinery of all the discovery rights and everything, you can get right into a lot of stuff. But the fact that you're coming to the tribunal, typically where there's an urgency, I think we see parties kind of effectively forego whatever, trying to stretch whatever discovery they might be able to get out of the tribunal process. And actually a lot of issues fall off the table, and you end up focusing on certain things that aren't typically very evidence-based, like in minutia of text messages and emails and things like that. So I think it's the timing that drives the needs and the practices of parties regarding evidence.
Thank you.
Aaron, any additional points?
I want to pick up on the fiduciary duty point. I think another criteria for thinking about the two is I do think courts are more inclined to hear fiduciary duty cases and will therefore be more deferential to boards. And I think if you're a shareholder trying to challenge the conduct of a board, you're likely to lean towards doing that in front of a tribunal as opposed to going to a court. I think who's the one bringing the application, I think will influence, and the likelihood that you are going to witness, you're going to want deference or not deference to be given to the.
Yeah, I want to jump in on that. I mean, and it goes to a topic we're going to talk about later, which is one of my pet peeves, which is the status of the defensive tactics policy, which is
whatever happens, we're going to get.
We're going to get it's the pre-BCE document. So it talks about shareholder primacy. So let's just talk about defensive tactics for a moment. There's also the concept of deference and how it's appeared in commission and tribunal jurisprudence. Is there deference? Is there not to boards? You're not supposed to be deciding fiduciary duty questions per se, but there's this inexorable overlap. And I know we can't get into these so-called watertight compartments like, was it Lord Acton wanted to do, or Viscount Haldane in interpreting the Constitution way back when in federalism cases. But take a defensive tactic where, let's say, a board of directors were to adopt defensive measures to protect non-shareholder stakeholders. It's unusual, but it could be done. Protect a lower priced offer for the sake of, let's say, the community or employees or Canada, say, in this charged nationalist environment, right? If that were to occur, I think a court interpreting the CBCA or governing statute would say, well, wow, there's actually an obligation to consider these other stakeholder interests, and deference would be accorded. If you follow the defensive tactics policy, you're charged with looking at what maximizes value for shareholders. And so there could, in fact, be tension between the applicable corporate law as to the propriety of a defensive tactic and securities law. So absolutely.
So Jason, that's
well,
you get. But what I would say, I think what I would say on this in terms of like the forum and all that, because we are going to come back to that,
sure.
Right? But in terms of the forum question, that for me, like we, as Aaron alluded to earlier, like when things that wind up at hearings very often have been complaints that have been raised with staff, and there's been some work and dialogue and back and forth going on before it escalates to a hearing. But forum is one of the things that we will endeavor to consider ourselves and discuss openly with complainants right at the very beginning, because one, we think it's important that everyone has an appropriate focus on this, because it does matter, as Aaron said, like choices have to be made and things like that. So, but the other thing that's highly relevant are the remedies available, so what is the right forum is also what is the practical forum, there are, as I mentioned earlier, the types of remedies that come under 127. Well, some of the types of remedies that could be very handy potentially, and depending on the facts in a 127 application, would involve taking away voting rights, would involve rescinding transactions, would involve requiring someone to dispose of securities that they acquired. None of those things under the Ontario Securities Act and most Securities Acts in Canada are possible.
Do it in BC.
You can
though.
do it in BC, yes, and so that's an interesting.
But it,
Telling me there's a chance.
so, but Jason, just going to that, then, the BCSC, British Columbia Securities has had an opportunity with those remedies to think about this
Yeah.
issue, and it looks like where they've landed is really the more traditional position that even if there are remedies, that there are actually matters that are better
Yeah,
suited to the courts than the tribunal. So
Yeah.
I'm just trying, does that sort of trump the remedies point then?
well, I don't know if it trumps it because it's only really engaged if you have the option.
Right.
So there's no option really in Ontario. Now you could go to court and there's maybe other ways to get through it somehow, like through 128 and such. But I think for practical purposes, I think it's necessary to look at, okay, let's assume it's all true. What is our tribunal? This is what we think about as staff, and so if people are aware, we think about what is our tribunal supposed to do with this, even if they were to find that there was a problem, and that can be a legitimate question. Yes, BC has, for their own sake, there are references there's a decision called Cohen in BC where they did not take jurisdiction on an application that was seeking to get at some of those remedies because they determined the matter was not in substance a securities law matter versus a court matter. And so, that's another gatekeeping, the commission there gatekeeping itself on trying to moderate what can come to it.
Yeah, and this is, we know a couple of instances where when the tribunal decided they had jurisdiction, like Echo Oro or Sears, they found a way to deal with voting rights, but it had to be very, very creative and
We also like to have our cake and eat it too in the practicing bar, because we'll beg you to take jurisdiction.
So
It's a statement against interest.
So,
You
yeah,
get
so
good and you're fast.
if anyone is expecting out of this, there'll be complete clarity on where
Yeah,
things should
and
go.
then they'll complain if you don't take the jurisdiction because you say, well, it's a purely corporate law matter. Part of the problem, in Delaware, you don't have a choice, right? The SEC doesn't do this stuff. And again, to suck up to you just a little bit. Aaron already did it, but it's actually extreme. It's extremely, you can't, when you go to court, speak to, the people like you to say, what do you think about this? It does help the public interest. You get swifter justice, you have expert people, but then on occasion where you draw the line about what you will hear and what you won't hear. And then to the extent that there are different remedies available in certain jurisdictions and others, and this, interminable, insoluble question about what are the boundaries in corporate and securities laws can sometimes leave you in a muddle. It's not perfect.
No,
but it works pretty well.
Yeah, no, and look, and we hope that this discussion can help adjudicators as they, as they wrestle with these issues when they come up. Okay, so now moving to, really substantive areas. We'll start with Jason. So what are the context? Well, the context within which a number of these discussions will occur with defensive tactics and potential exemptions from takeover requirements is the 2016 takeover amendments, the largest, the most significant change in the bid regime since 1987, when the modern regime was put in place. So I'm just going to ask again, Jason, to very briefly summarize those changes, and then we'll move into the discussion.
Yeah, the changes are important because they really altered the whole context for takeover bids, but it's had further effects for M&A hearings, certainly. So in the changes that were made in 2016 broadly were intended to do a couple of things. One, they were intended to alter the sort of dynamics of takeover bids as it hitherto had been, so that now shareholders would be able to have a sort of minority voting power, effectively, and more pertinently, perhaps, that boards of target companies would have more time and discretion when responding to a takeover bid. So the three changes were adding a requirement that all takeover bids have to have a minimum 50% majority tender standard. In other words, if more than 50% of the independent shares are tendered to the bid, then the bid can proceed. If not, it cannot proceed. So that's a statutory minimum tender requirement. There was no such thing previously. The second is that assuming a bidder were to obtain that minimum 50% tender, they then are required to extend the bid for an additional 10 days. Again, that never existed before. But the purpose behind that was to address what was understood to be a pressure to tender concern. In other words, in a world where a bidder can take up shares, have what was known as an any and all bid, and could take up shares just depending on whatever it got in the box, so to speak. There is a concern that shareholders might be tendering not because they think the price is great, but because they're worried that they're going to be left in a controlled illiquid company afterwards. And so that's the purpose of that extension. And then the last major change was the increase of the minimum deposit period for a takeover bid from 35 days to 105 days, subject to discretion of the board, the target board, to waive that down to as low as 35. And that additional period was really all about giving the target board more space to respond to the bid or source alternatives. And so those are the key changes.
Okay, so, now Jeremy, will start with you. So we have the National Policy and Defensive Tactics.
Yeah.
Which has been around for some time.
So 97 when it first.
Yeah, actually went earlier. We just renamed it, so that's one of the tricks. If you rename things, every now and then people think it's new.
Yeah.
So it's older than that, and so its application has really come, more recently in two contexts: poison pill, and private placement. So in poison pills, part of the thinking, as Jason said, was increase the time, we put in this protection.
Right.
Maybe you never appeal hearing again, and
right.
Then we're shocked that actually we've had four. Three of them, the pill was straighted. That's Aurora, Greenfire, and Bitfarm.
Yeah.
Bison, it was not, and so from your perspective, these decisions, some of them, really saying, you can't modify the bid regime using a pill, or take away an exemption that someone has, or reduce the bid period bid threshold from 20 to 15 through a pill.
Right.
And then your Bison, where the pill was permitted because there was some concern about the bidder using cash settled swaps to perhaps get an unfair advantage.
Yeah.
Do these decisions make you feel better about the national policy or worse? And how does this help, advise clients?
Wow. That's let me take my response in 6 parts. No, let me start with just a general point. I think that we have a kind of common law now approach to defensive tactics because the policy hasn't been updated, and there's been some incremental decisions that have been made. They build on each other. Sometimes you have things that are in tension, and sometimes when that happens and they can't be reconciled, there may need to be a new policy or a staff notice or what have you. So that's just life, and we can talk about the specific decisions and the impact on the market, and I'm happy to give you my specific views about Bison in particular, but don't know who's entirely on the line here. But I do think,
candid conversation.
yeah, no, I appreciate that. But I do think that you mentioned private placements. You mentioned the fact that there have been the bid amendments. So now pills are not really used to give you more time. They're really intended to prevent creeping.
Yes.
Right. And hard lockups. Right. And the defensive tactics policy as drafted doesn't really advert to that. It was more about time to run an auction. In fact, it says auctions are the preferred way to go. That's right. This was before even the Paramount decision in the US that said, Paramount and QVC, that there's no single blueprint. You don't always have to run an auction under Revlon. So I just think we need a refresh. And there's also proxy contests. And increasingly we see, and we'll talk about this, the commission, the tribunals being brought in to adjudicate, securities law issues in respect of the proxy contest. So it might be nice if there was a new codification or a new articulation of the principles. I appreciate it's very difficult to do that. There's limited bandwidth at the CSA. So I think conceptually, to me, that's the problem. I think the way it's actually worked out, the path dependence and so forth, has been pretty good. I guess what I would say is that when you do get conflicting decisions, to the extent there are any, you have this notion of dialogue. It might be time for, the staff and the commissions on the policy side to respond. And sometimes there are gaps. Now, I can't blame the tribunal for that. They're just deciding a case before them, right? I mean, they got to respond to the facts of the case. There should be some, hopefully judicial restraint or modesty, because it's tough to know. And I appreciate they're sensitive to that. But we talked about a bit before about obiter, like Jim Turner's obiter, not to single him out, in Hudbay Lundin, which caused a big set of questions amongst the financial advisor community, right? And in a case like Bison, the concern, and don't want to comment on if it's rightly decided or not, a policy decision had apparently been made about the use of swaps. And then the first time it really gets challenged, there's a sense in which that policy decision is somewhat, let's say, undermined or distinguished. But there's still a lacuna now in the market about, well, how do you use the derivatives or not in a stake building campaign and so forth. Can have the perfect be the enemy of the good? But just to summarize on all this, I think the incremental case law is good. I think having a refresh of the defensive tactics policy would be helpful. And I think tribunals will increasingly be needing to focus on proxy contests and other kinds of situations, in part because hostile takeover bids have come down because of these bid amendments.
So, Karen, do you disagree completely with Jeremy? I hope.
I'm going to more agree with you. I think that the amendments did improve the clarity around this, and I think the three cases that were that you talked about all were essentially preserving the status quo. And I think you would say, Nazem, that that's good because that creates predictability in the takeover bid regime. Bison to me is an outlier, and I think it is a very heated set of facts, very specific. Sure. And so I choose not to really think of that as a pill case. I think of it as something else. But I do think the cases, for the most part, have come around the principles that the rules are pretty clear, and we've created a very narrow set of circumstances where these pills matter, and people should not try to rewrite the rules that have just been rewritten. So I think the cases are helpful.
And Jeremy, I think we would agree that, and I think the tribunal, when commenting on public interest, really has to balance the facts in front of them while knowing, the decisions of policy implications. But this question of regulators always reviewing these decisions and thinking, okay, do we need to do some policy on that? So what I'm going to just move a bit to private placements, which is the other side of Aaron, and then Jason, I have your thoughts first on all of it, together. So in private placements, we've had again a couple of decisions, Hecla and AMIA, where the court commission corporate securities law issues could easily have been in front, really more so front center than even pills. Both were not. There was no intervention by the tribunal in both. In Echo Oro, which is a proxy contest but came through the exchange appeal, so different sort of mechanisms, so maybe treated differently. There was intervention, but how do you see it in terms of where there's a framework being developed here and being applied? How do you see that?
Yeah, so I think I'm actually just going to echo the comments about the policy, defensive tactics policy, because in the aftermath of the bid rules, we used to have, there were years we had 23, 24 hostile bids a year. Now we have 2 or 3. But that doesn't mean there aren't contests for control. It's now in the proxy contest. So that's where all the action's happening. And so I think if we could, and I think this is instructive for how certainly I look at the AMIA case. I mean, Hecla, I think, that was that was right after the advent of the new rules. And I think everyone anticipated that private placements were going to be the potential way to stymie a bid. And so, we need to be very careful in examining. But then, since that time, the landscape's changed. I mean, AMIA involved a proxy contest and then a bid, and I think if you're looking in through a framework of like, well, this is a proxy contest, no, this is a bid, so I'm going to look at the bid rules and how the jurisprudence in the past is and how the defensive tactics policy would look at it. I think AMIA makes some sense in that context, but broadening the lens as to what was actually going on there. I mean, that was a knockout battle for months and months and months, and so I just think. While I kind of the Hecla framework makes sense, I think the way then you try to apply it to AMIA's facts are kind of challenging, because I think you get wrapped around like, well, is the bid imminent? Well, whether it was imminent or not, there was something going on for months and months, and yes, there was court action and all these other things. So I just think that this to me is where maybe it's not so much forum choice, but I do think if we constraining, I guess trying to cut some facts out so that you can look at it within an existing framework is problematic. I just think this case called out for broadening the lens. And again, if we had a different defensive tactics policy that was maybe more reflective of the current landscape, then I think the decision might have still come out the same way. But I think maybe as practitioners we might have felt more comfortable about the analytical process that got to that decision. And then on the because the other thing I'd say, going back to the point about the the fiduciary role and the like, there is a tendency I find to oh well, that's fiduciary, that's not really our there's some stinky stuff under the hood here, but that's not really our bailiwick. So but we're just going to look at what the outcome was. But I think if you ignore the stinky stuff under the hood, that actually you might be missing something, right? Like if we're talking about public interest, at some point you don't necessarily have to judge whether the director behaved, crossed the line of breaching fiduciary duties. But if they're coming close to the line of what we might view as is acceptable conduct in the capital markets, that might be worthy of a bit more scrutiny and factoring into the decision. In any case,
Well, and to underscore that, just like take Aurora, and I know people aren't familiar off the top with all the case law, and I might not be either, so I'll make some stuff up. Correct me. But in that case, exactly, it's elucidated on me before. I got the word in there. No use cases, but kidding aside, in that case, I think one of the problematic issues, if I recall correctly, was that certain insiders on the board may have tipped a bidder to come in and try to make an acquisition proposal, while the company on which they were directors was trying to pursue an alternative acquisition of their own, and the two things were irreconcilable. And so in that case, and I'm not being critical per se of the decision, but it was found that, okay, well, we'll have disclosure as a remedy. We're not going to really police whether there was a breach of fiduciary duty or breach of confidence by these directors, who are arguably faithless fiduciaries, by leaking, and just say, well, now the market knows this and we've done our job, right? But if you took a more holistic approach, you might say, no. This is conduct that's undermining a board process where some people have gone rogue. I think a similar argument was attempted in Greenfire. It was unsuccessful, so I'm just not commenting on the facts per se. But when people are acting in manners that are violative of their corporate law duties or duties of confidence, if you think about it in the context of a contest for corporate control, that may be something that the tribunal wants to think about in formulating remedies. But again, we get into this, overlapping jurisdiction question, which is a muddle.
Yeah. So Jason, obviously on the private placement, there's this tension between allowing the issuer to, go around its business, while protecting shareholder rights. So in some of these other, examples.
So I have a few thoughts. One, I would say in terms of updating the policy, sure, I could see the benefit of that. It was written at a point in time, and things have changed. But I would argue, without maybe going too far, to suggest that the policy has almost been sort of the living tree, because it's been adaptable to a lot of different situations, and you can frankly, for the most part, other than a pure defensive, just say no defensive tactic, you can find ways to work with the language that's in there that suit how I imagine as a tribunal or panel that how you're seeing the situation. So the auction language in there has been used, including in Bison, that's my recollection, as supportive. Like that's where the defensive tax probably upheld the pill, right? Mm-hmm. Because one of the theory was that by preserving the pill, that was at least at a minimum an expedient to assisting with maintaining the potential for the friendly acquisition under the plan of arrangement, which compete with the competing transaction. So I think there are ways that panels have been able to still work with the words and get to outcomes that arguably you could say are board friendly.
I think Tim has a question.
Yeah, I'm sorry, I didn't want to interrupt Jason. Jason, did you want
to? Well, I'm in your hands, Tim.
No, just so I'm not here because you're out of time. I'm here because there was a question. So I'm
it's good. We actually decided up front that anytime there's a question, it gets priority over.
Well, I'll let you decide that. I mean, it's an interesting question, and we did touch on this a bit more last year, but it might be a whole panel discussion on its own. So, in terms of proxy fights, what can tribunals do to more efficiently address those if the case comes before us?
So I can maybe, because this is consistent with what I was going to talk about. So because the point was raised, well, should the defensive taxes policy be expanded in a way to encompass, proxy contests in those situations? And we've seen cases now where proxy contests have been a part of some of these decisions. And I think that's where we get into a very, very interesting question, because we have, described in the Eco Oro decision, commentary about that proxy contests are contests for control, and the same principles of fairness to shareholders and such are pertinent there as well. So there's reasonable and appropriate scope for tribunals to consider defensive tactics proxy contests, for example, through a public interest lens. We just don't have a policy that backstops that, although you can analogize to the policy presumably. But the difficulty, again, to some sort of is to me right now, and I'm not these days, it's the remedies, right? Mm-hmm. So it's difficult to articulate, to actually change the policy without having remedies that could actually be satisfactory if that policy is prevailed upon when someone is making an application. And so that's a real issue there. So
so that's, and it's interesting because BC, which has remedies, I think the issue that's coming up is that the takeaway regime and the conflicts regime is ours, so to speak. Securities regulators have created those regimes. Matters that come within that, the defense protectors policy for bids comes, there's a handle on it because it's an entire regime. Proxy contests, we have bits of it, but nothing comprehensive. So for adjudicators who are reactive, right? I mean, they're, and we are the regulators, Jason, so that it goes to, and I'm curious about your thoughts, whether what we're hearing really is that it's really unfair, for these things to all start moving to tribunals in the absence of the regulatory side putting forward a perspective and maybe some things around it that then, the adjudicators can deal with, as opposed to asking them to build that, as you say, through like a common law approach. So I'm curious, Karen, is, where you come on this issue. Sorry, almost last word.
Last word?
No. We have a few minutes still.
I think it's a challenge. I do think trying to analogize is difficult. We've talked about voting, and taking away people's voting rights to me is not the right place to go. And I think it's a rabbit hole you're going down a rabbit hole to try to distinguish the right people voting and a meaningful vote or an empty vote. And so I think, what is the remedy?
Well,
and
I've got some thoughts.
You've got some thoughts.
I mean, again, it depends on the conduct, and we go back to joint action because that's often one of the things that we see before the commission's tribunals. And I think broadly speaking, we have to encourage shareholder democracy, and that's why the Northwest decision, in some respects, which is very friendly. I mean, don't want to quibble with the result right now. I think they're, but there needs to be consequences for people breaching securities laws and acting jointly, and to say, oh, and I mentioned this in Aurora, and I'm not suggesting it was wrongly decided, but it just get it out there. We were joint acting. Well, one thing is if you find that somebody was a joint actor, and I know it's a high bar, you could say that you can't have acquired more stock. So you were making an illegal bid, or certainly there should be a penalty for your disclosure violation. Another consequence about voting might be, well, you may be able to vote, but you can't solicit, right? So if you're an activist in a wolf pack and you're trying to organize something, but you're doing so skirting securities laws, you might say your punishment for having breached the law is that in this proxy contest, you can vote your shares, but you can't be organizing a cabal. That might deter activists and have a salutary benefit in the market. Finally, and I don't really think we should go there, but it would be another thing to consider is liability for certain statements that are made. I know the securities laws exist, but having staff or people in force, like in proxy contests, anything goes, and you've got activists who are, flame throwing out there, they're not subject to the same strictures as an issuer is. And so again, if they're misleading statements or short selling or other things, there are a range of measures to constrain opportunistic behavior. And there needs to be a balance between that and having healthy shareholder democracy, which allows for the rough and tumble of voting people in and out and getting your way in the board.
Yeah, that goes like a whole separate panel you could have, which is the line between, and this does come up, between enforcement proceedings, other things that are, the kind of things, if the tribunal got them as a matter of a real time,
Yeah.
the tribunal would say, well, this is not really a pill hearing question. This is the kind of evidentiary record and outcome you're looking for is really more of an enforcement proceeding. But then the question becomes, how do you kind of manage those? So that does come up.
Yeah.
Now we just have a few minutes, and Karen, I wanted to talk about one of.
We could just talk
just
about the
talk.
tips
So-
for the.
So yeah,
what do you think?
so we have.
It's my favorite topic, but it isn't everyone.
Well, so this was just the question of, Optiva, the relief wasn't granted from the majority tender requirement, whether there may be circumstances where it could be, but.
Next year we'll do a whole panel.
We'll do a whole panel on that.
Yeah,
That's,
yeah.
but in the few minutes, hopefully we have a few, more than the 1 minute it shows. If.
Okay, all right.
So the last word. So, obviously it's great. You've been, working all these things in, but Karen, I'll start with you in terms of, any, thoughts for our adjudicators as they're doing hearings, writing decisions.
Yeah, I would say two things. I think the first thing is we read these decisions and we care about the rationale, but the facts are hugely valuable to us because we are advising clients day to day on what they should do. And, we could talk about Northwest on another panel, but, clients say, can I go to a meeting with another shareholder? What can I say? What can I ask? What can I do? Should I take notes? And so a case that lays out clear facts where we're allowed to infer from the judgment how those facts were received is super helpful to us giving advice day to day. So timely decisions with good facts that are clear is super helpful to practitioners. And then the second thing I would say, and I wrote down these words from you, Aaron, you talk to the commission staff and they take up arms for you. I do think it's worth making panels aware that even though these aren't enforcement hearings, staff and the commission representatives are not objective third parties. They are objective experts. They may have their own advocacy. And so sometimes I think our impression is that they are received by the tribunal as if they are an objective expert, and they are not necessarily objective. So that's something I would
So
put on the
we'll be giving
table.
Jason the last word, so that no one can respond to it. But yeah. So Aaron.
Yeah, I echo Karen's comments. I think the other thing is sometimes statements which I think are obiter come across as sort of sweeping policy statements, like the Northwest comment. It's better to let shareholders, I'm paraphrasing, or fly under the radar. That was the phrase. It may be from a policy perspective better for that, which I get it. But the problem is then you extrapolate from that, and then be careful, because then does that give license to bad actors to, okay, well now we know what we can do. We can operate in the shadows. It's an evidentiary problem. So I guess I would just say, make sure the decision doesn't decide too much, in part because they are so fact dependent. But otherwise, I think hopefully this session is helpful in sort of instructive in terms of what the context is where we are bringing things and what we're trying to take away. But I'm sure, Jeremy, you've got it.
Yeah, go ahead, Jeremy.
Can I say something critical?
Of course.
Okay.
Jason is always happy to take
So,
this.
this is about the tribunals a bit. No. So look, the two decisions that I think have caused me the most heartburn, in part because I had clients on the wrong end of both of them in a way, were the Hudbay-Lundin decision, which, if people may recall, that was a case where there was a merger between, or proposed merger between Hudbay and Lundin, and there was going to be a hugely dilutive share issuance, about 100% of the share capital of Hudbay to be issued to Lundin, and there wasn't going to be a buy-side vote. And at that time, the TSX had a very, very clear rule, which was actually touted as a benefit in some ways for listing on the TSX, which is that no buy-side vote required. And there was even an Ontario case, Goldcorp and McEwen, that said no buy-side vote required. And yet in that judgment, the OSC, and it was Jim Turner, who also had the obiter comment about financial advice. So I don't mean to be giving Jim a hard time. He taught me M&A when I was at Torys back in the day. Great lawyer, fine mind.
Legend.
And it may have been the right policy decision, but the market had an expectation of what the rules were, and the rules were changed by the tribunal. And that's my issue also with Bison. I think it was pretty clear that the way Brookfield planned things, and I was not on Brookfield for sake of disclosure, that what Brookfield did was within the lines. And I don't think this was so far outside the lines or the things that were contemplated when this policy came into fruition that it could be seen as abusive. I think it was the tribunal effectively saying, we don't like these rules. And you know what? That's fine. It may be a bad rule, and it may have been a bad rule that the TSX allowed a dilutive deal to go ahead. But my preference would be you let the bad deal go through and note your extreme displeasure and discomfort, but that your hands are tied, and then let the regulators clean up the mess, or the commissions rather, and the legislatures, because predictability and deal certainty is extremely important. I know it's appreciated, and I know some things do cry out for relief, but that to me, I would say is the most controversial thing I find when the tribunal does that.
So, Jason, you can have the last word, and then we'll finish. But obviously, Canadian Tire, many could say the same thing, but I'll pass it over to you, Jason.
Yeah, no, I think what I would just say is that like these decisions really do have policy implications, and as everyone's spoken to, practice implications. So each one of these are important and is important, and there is precedential impact. I think it is. I think it is helpful when tribunals endeavor to provide or think about frameworks, or possibly adjusting any existing frameworks that are, and this was done recently in Bitfarms. But I mean, I feel like the Heckler framework was strained, like in the Amy example, for example, but I think everyone was trying their best to work with it. But so frameworks, I think, are helpful, but could also be revisited. But I think what's very helpful for everyone is to have as much as possible, a really clear articulation of the rationale for intervention on the specific facts, and even kind of state that, but for certain facts, may not have been intervention. This type of thing, I think, is helpful, because it really helps, I think, people plan and understand how that would be. And then in terms of staff's role, there may be different approaches by staff, but I can say in Ontario, yes, we do typically come and make and present a view that is coming from our best feeling of what the right policy oriented answer should be. Obviously, has to be consistent with the facts, and we're happy to answer questions about that, and deal with that, in the hearing as other parties would.
All right. Well, thank you, everyone. And Tim, I'll pass it back to you.
Thank you, and thank you, everyone. And look, I really appreciate your candor. I mean this. I really appreciate your candor and the sort of not only the discussion of the substantive issues, but the giving us more insight as to how this stuff matters when you're advising clients. I mean, that's one of the main goals of this program. So I really mean it when I say I appreciate your candor in that. One thing I wanted just to sort of clarify a bit, and I wasn't the only one in the audience who picked this up, but a couple of times over the last session have talked about conduct that's abusive and therefore warranting intervention under Section 127 in Ontario. That's the section number. But at the risk of sounding like I'm at a book selling thing where I'm selling my book, the Riot Platform's decision, and I'll put the link in the chat for everyone, goes through all of that history and I think comes out at a different place. So while behavior that's abusive no doubt clears that standard, that's not the standard. Abusive is not the standard. So I just want, for the benefit of the audience, at least it's not in Ontario. At least it's not in Ontario, and at least not for now. The law.
And Tim, thank you for
and only for takeover bids so far.
Well, yeah, and private placements in the face of takeover. But yeah,
we were debating how much.
Yeah, we were going to talk about. We had a whole pre-call about how much to go.
But thank you for that, and that's right. I mean, so it's always good. None of this is legal advice, please.
or binding decisions. So anyway, we need to wrap it up. Thank you so much, everyone. I really appreciate it. Nice and great job. And by the way, we'll get feedback from other attendees. I thought this format worked really well, so I appreciate you all coming to the room and having the conversation. I think that contributed to the richness of the discussion. So thank you so much for all your time. Really appreciate it.
Thank you.
To everyone watching, we'll take a break now and we'll resume. We'll aim for 2:35, but we might be a minute or two. Just we'll aim for 2:35. See you soon. Thank you, Sandra. Welcome back from the short break, everyone. We'll move on to our final panel. One of the interesting things I think about expert tribunals is that in many cases, people who are appointed to these tribunals allegedly come to the tribunal with some expertise because they've been working in the relevant area for a while. And then we end up on a tribunal and we are less plugged into what was giving us that expertise in the first place. So it's often extremely important and valuable to have discussions like the one we're about to have and hear from experts like the one we're about to hear from. We're very fortunate to have Kevin McCoy here, who's Senior Vice President, Market Regulation at CIRO. And full disclosure, Kevin and I used to work together many moons ago in compliance. I know Kevin was an expert back then, and he's even more of an expert on this now. So he's going to help us understand better what's happening in markets today, what the trends are in trading and technology and so on. So Kevin, we appreciate your insights. Please take it away.
Great. I'm just going to quickly share my screen. Thanks very much for the very kind introduction. And I will do my best to give you some insights into the way that we see markets today. I have to apologize. If you see on the slide, I was supposed to be joined with Sonali Gupta-Baya today, who is our Vice President of Market Policy and TCC. Unfortunately, she was unable to make it. So I will try to make her proud by doing the best that I can by taking you through what I think is some interesting things. So I'm more than happy to take questions along the way as well if there's something that comes up. So if somebody can just interject, and I'd be happy to take those as we progress. So I think it's really important when we start to look at kind of the current state of market structure and where we are today, just to have a really quick look at where we came from and how we arrived to where we are today. So just taking you back, I guess, to a little bit of history, back to the demutualization of the TSX, where prior to that, the Securities Exchange and the Stock Exchange was very much working on a single market model, and it was operated as a utility. That all changed in the year 2000. Another big event was in 2002 when the ATS rules were implemented, which allowed for basically competing venues to be able to make available for trading securities that were listed on an exchange in Canada. It took a few years for adoption. The first one we had was Pure Trading, was launched in 2007. That was, I guess, the early adopter. Shortly after that, in 2008, we had Alpha ATS, Chi-X Canada, Omega ATS were all launched. So by 2008, we had a fairly robust environment of multiple competing marketplaces. So I think pictures tell 1,000 words. So prior to all of this, where we all started, it was a really simple world. We had clients, we had dealers, we had institutional investors. They were all coming into the dealer. The dealer was managing the execution of that order on one of the exchanges in Canada. At that time, we had the TSE, the TSXV, the Alberta Stock Exchange, and the Montreal Exchange. And each of these were trading listed equities. After the ATS rules, the world got a little bit more complicated. So as we got all these other alternative markets up and running, we got a lot of different order books. We had a lot of different options where people could actually go to execute and enter their orders for equity executions. If that wasn't complicated enough, where we got to is this is kind of where we are today, where we have a lot of consolidation. There's a lot of venues that are operating multiple different order books, meaning that they're operating these distinct and unique markets that each have kind of their special little features of what they do. I put on the bottom there too, we also have two crypto exchanges that we regulate. We have CoinSquare and NDAX right now. So this is kind of the world as we see it. It's a lot more complicated. The way that orders get into the book is different. And we're going to go through a little bit of that in the next few minutes. One thing I think is also interesting when we look at that kind of very complex market landscape, just to see what does it look like in terms of where are the trades actually happening across that environment. So we still see that the incumbent exchanges, both the Toronto Stock Exchange and when we kind of go on the volume side, the TSX Venture Exchange, still have a significant percentage of the overall trading volume. That being said, there is a fairly good dispersion of the rest of the volume across many different venues. This was one of the purposes of the kind of the introduction of the ATS rules, was to be able to provide choice and to be able to provide additional competition. So through all of these changes, through all of this development, through all of the progress, there's a couple of things that I thought would be interesting just to lean into a little bit, just to provide a little bit more detail. One of the things that the ATS introduction really introduced is the bifurcation between dark liquidity and lit liquidity. So what I mean by dark liquidity and lit liquidity is the lit liquidity is the one that actually is contributing to what you would see as the public display. So when you look at the national best bid and offer, that's made up of the protected markets that are contributing to that lit quote. The dark markets don't contribute to that. So they have kind of special rules. There's no transparency to it. And typically what happens in those dark pools is that it's dark liquidity that's acting and trading against dark liquidity. There was a lot of reasons and rationale why that made sense to introduce the dark liquidity. A lot of that was to be able to, from an institutional investor point of view, to kind of manage the risks of information leakage. So there's often a lot of information that's tied to a knowledge that there's an investor that has a large size order. Historically, those large size orders were handled by the upstairs market. So you would have the trading desks at all the different big firms, and they would try to kind of outside of the market mechanism, try to be able to match buyers and sellers and to find counterparties for those larger trades. So one of the benefits of introducing this dark liquidity was a way to bring some of that liquidity from the upstairs market, bring it down onto the actual public market to make some of that liquidity, although it on the dark terms, make it more accessible to the general investing population. So there was a lot, I think, of advantages for doing that. One of the things that I think is interesting about dark markets is because they don't contribute to the price discovery mechanisms, where they're not actually looking and kind of contributing to that quote, they're very much operating off of what that transparent quote is. One of the typical orders or the typical ways that orders are going to be executed on a dark market is at a midpoint. So it's always going to be referenced against what that public displayed bid and offer is, but it's going to use that and it's going to be able to actually provide a better price to both the buyer and the seller of that order by able to kind of split the difference between the two sides of the quote. You know, from a regulatory perspective for us, it's interesting because it creates one more incentive why somebody might want to do something manipulative with the quote. Because if you're actually looking to get an execution that it's benchmarked against that quote, in certain instances, it may be beneficial to be able to try to move that quote to get a more favorable execution in the dark market. So as we saw these dark markets grow, it's something that we very much from a supervision perspective, you know, keep in the back of our minds as we're looking through activity to see if there is people that are trading both in the dark and the lit, and what the relationship is from trading on both of those markets. There's also a lot of opportunities within the dark markets to have kind of special terms or specialty markers that are put in that. So for example, I may want to trade in a dark market, but I may want to only trade against larger counterparties. So I have the ability to put minimum size quantities in my order. So it's only going to trade when it can get me a trade of a certain size. There's also going to be the opportunity to put limit prices in those orders. So I can put an order in and just say, execute that order at whatever the mid price is. However, I can also say, put it into the mid price, but this is the maximum that I'm prepared to pay, or this is the minimum that I'm willing to accept for my trade. So that means that those orders actually are going to go in and out of being in an executable form, because all the executions that happen in that dark market have to be done in the context of the lit market. So for example, you can't have that execution that's occurring in the dark. You generally can't have that execution done in the dark if it's outside of the public quote. So it's very much contingent on whatever that kind of displayed bid and offer is, because that's going to determine the executability of any order that's sitting in the dark book. So where did the dark markets lead us to? So one of the things that I think a byproduct of this came was some of the more advanced order types And I want to spend a few minutes talking about one of them that I think is, it's an interesting order type, and I think it's one that has grown in its significance. We saw these introduced into the Canadian market probably about 6 or 7 years ago. And the order that I'm talking about is conditional orders. So this is a concept that wasn't unique to Canada. We saw this in other jurisdictions around the world, and there was a desire from institutional clients to bring the same kind of technology here. It's somewhat interesting to me because this is really mimicking or replicating some of the effort that historically we would have seen done by the dealer themselves that's now being accommodated through kind of specialty features of a marketplace. So conditional orders, for the most part, operate kind of, if you will, on the side of the public book or the order book for that particular market. What I do is I put in a conditional order, and there is mechanisms that are prior to order entry to kind of to be able to source counterparty liquidity for me. So it's going to look for other orders that are coming in and looking for other opportunities to be able to have a potential match. The one other interesting thing is once they've had this certain amount of ability to negotiate, whoever the initiator is of that trade has the opportunity to do two things. I can either confirm my intention or I can turn it down. This is a concept that's known as fall downs. So when we started looking at some of these features being introduced into the marketplaces, there was a concern that, are people using these conditional order facilities just to kind of poke around and see if they can use it to discover where there's pools of liquidity or where there's interest in buying or selling of a certain security? So there was requirements put in for marketplaces that offer these conditional facilities to be able to monitor what those fall down rates are. So to see if there is a client that is frequently putting in conditional orders, but is really infrequently following through to an execution. This is something that we don't actually have access to because we don't get the data in for us to be able to look at that. But we very much work with the marketplaces as they try to kind of control that. And they have across the board, and they do it in different ways, have put in, there is consequences for an investor who kind of triggers whatever one of those parameters will be, where it's an unacceptable fall down rate. There's another couple of interesting features just through some of our marketplaces. And again, I think this kind of carries on that thing, the concept of marketplaces introducing some features to kind of replicate the work that dealers had done. I don't think it's altogether bad because I think in a lot of cases, what it's been able to do is democratize some of the abilities that at one time, it was only the larger dealers that had access to the technologies to be able to support some of this. So I'm just gonna touch on two of them. So there's one feature of a marketplace, which they call PureStream, and PureStream is intended to find buyers and sellers that are both interested in trading against each other, but just in the context of the market. So it may be two parties, one buyer and one seller, that want to trade a certain percentage of the market that trades. So once these streams are created, if there is a natural execution for 1,000 shares on a market, and if the stream wants to be 10% of that, the marketplace will automatically execute a 100 share order at that price to be able to follow along what's happening in their market. And again, it's kind of interesting because this is the types of things prior to the introduction of these onto the marketplace space that dealers would have done themselves, where they would have had to kind of monitor the market and they would have had to execute orders sort of as a percentage of what they saw happening on the marketplace. One of the things that we often see as well, and it's no surprise to anybody, is the advancing of technologies that are used as well. And this is, we started out in an environment where there was kind of wide access to machine learning. We're now pushing our way towards generative AI and those more complex tools. One of the marketplaces also has a facility which is called a quote decay signal. And this was unique when they introduced it because it's the first time that we've seen it. And it's a technology that's an opt-in for the client. And the intention of it is to be able to use kind of predictive technologies to be able to predict when there is going to be a change in a quote. And if it detects that there's going to be a change in the quote, in the interest of protecting the client from adverse selection, the technology will automatically go in and reprice that client order to reflect a better execution in the context of the anticipated crumbling quote. I'm not sure exactly what the take-up is, but again, this is something that, you know, it's more of a marketplace actually managing the order execution as opposed to the activities that typically would have been done by the dealers themselves. A couple of things just in terms of electronic traders. This is something that, you know, what we see is a real evolution in how electronic trading has developed. When we first saw electronic traders, it was a small concentrated group that had access to significant technology resources. The barrier to entry in that electronic trading space was extremely high. What we've seen is, I guess, what I would say a democratization of that technology and the ability to kind of lower that barrier to entry. What we see now is that kind of concept of automated trading, you know, using models to trade, the black box trading has really expanded beyond that. What we saw originally was that very small core group to actually more mainstream investors. So we do see hedge funds, pension funds, other buy-side clients that are able now to be able to adopt that technology. I think that this will continue to rise as well as we see more adoption of even more complex and more complicated technologies. I think it's going to provide more opportunity to build more tools for more investors. And I think this is something that, you know, we're in the position of looking at, being aware of, and making sure that we are going along to make sure that any kind of oversight, ever kind of market monitoring that we do is taking all of this into account, because I think we are going to see changes in the way that we see executions happening, just because the adoption of the technology will continue to increase. One of the things that we're also looking at is, you know, we've always considered every security that trades in a market pretty much in the same, and basically have set a set of standards, a set of requirements, a set of rules that it's a one size fits all across the board. I think we're starting to get to a point of understanding that the way that the markets have grown, the way that the product types have grown, the way things have changed in the markets, that we have to take into account that there's absolutely pieces of our equity markets that are not necessarily like the other, and they do have some unique features. One of the things that we have just finalized rules on, which will be coming into force in January, is the ability to be able to support net asset value trading for listed ETFs. This was a little bit of a hard one for us to originally get our heads around, because the whole concept of an ETF, although they are registered and they're recognized as a mutual fund, they do trade in a continuous market. So the concept of having something that trades in the continuous market, but he'll still to be able to build a facility where you can actually trade that at an end of day value. All that being said, this is a very important part of the liquidity provision piece of the ETF industry, knowing that we have this special group of dealers that have special arrangements with the issuers to be able to be in that continuous creation and redemption phase. So we're introducing rules that are going to add transparency and provide kind of a less friction way for dealers to be able to execute these trades on a marketplace at the net asset value that's calculated and disseminated by the issuer on the public markets, and give that extra bits of transparency. So these are the kind of things that we're looking at, and I think we'll continue to look at other areas of the market that may need to have some special considerations when we look at the rules and the regulations that we apply against them. A couple of things that I would say that are on the horizon, and again, these are not necessarily ones that are unique to Canada, but we see them across other jurisdictions as well. And these have the possibility to make fundamental changes to the way that our markets operate. One of them that is talked about often is extended hours trading. In some jurisdictions, they've gone to a 24/7 model to provide the access to trade on an around-the-clock basis. We do have interest in our own markets for people to be able to extend the hours in which they trade. So that's something that we will be looking at in order of, once we have markets that are interested in providing those kind of services. It's something that we don't have a choice, but we're going to have to look at. But again, we've always been kind of subject to that typical normal trading day clock. This is going to have a lot of implications in terms of the systems that everybody uses. We're a batch processing world, so it's really going to cause us to rethink the way that we do things. One of the other big things is the concept of notional trading, where again, we've always traded in share value, we've always traded in board lots. The whole concept of notional trading is supporting investors that want to trade dollar values as opposed to trading share values. So we've, I guess, flip-flopped a little bit about how we name this. So notional trading is where we landed. The discussions first started as fractional share trading to support the ability for investors to be able to trade in less than one share. But that is something that is gaining momentum, and I would expect that we would see some movement in that in the coming months or years. The last thing I just really wanted to touch on is the increasing use of AI technologies and the way that AI technologies are incorporated into models. We know that even as a regulator, we're looking at how can we incorporate some of that technologies to do what we do better, faster, more efficiently. And that is absolutely happening right now throughout the equities trading and market environment, both at the marketplace level and both at those that are accessing the marketplaces. We're going to continue to see that, and we're going to continue to have to address the additional risks that come with that. But again, that's something that is going to has a lot of upside, it has a lot of potential, but it also brings along a lot of risks that we're going to have to be cognizant of. That's really the comments that I wanted to make today. I'm happy to answer questions if anybody has any, or Tim is more than welcome to give me the hook. So
no hook.
No.
If anyone has a question, you can put it in the chat. I haven't seen any, but thank you, Kevin. That's very helpful. I know it's impossible to get us all up to speed on, being on the cutting edge of everything that's happening in 25 minutes, but it's very interesting to hear about the trends. It's not surprising to me, at least, to hear about how much technology is driving those the evolution. So it's good to have a touch point for all of us there. So Kevin, with that, I will thank you very much for taking the time to contribute to this, and really appreciate it.
My pleasure. Thanks very much.
All right. Thank you,
Good afternoon. Bye-bye.
Thanks. I'll ask everyone just to stick around for a moment. Just for 1 second, we're just going to stop the recording. That concludes the program, but we'll stop the recording at this point, please.